All right. Good morning, everybody. Good morning. Good morning. My name is Dana Sparks, and I am the director of the Georgia Real Estate Academy, which is the school that is offering this class for CE credit. This class is, what is this class? This class is Know Who is Protected Under Fair Housing and What the Laws Are. It is GREC course number 62099 through the school, the Georgia Real Estate Academy, which is GREC school number 6915. So we will get started in just a moment. I am going to mute everyone, and I am going to ask that you do ask questions through the chat function. We are so excited to have Amee Davis, who is named partner and closing attorney with Davis & Associates Attorneys at Law, as the instructor. So it'll be really great to get an attorney's perspective on the fair housing laws. Amee does a robust closing business and is very, very well versed in the GAR contracts, as well as the RE forms contracts, as well as all of the latest and greatest issues, legal issues surrounding real estate, especially in our market. So we're really excited and looking forward to hearing Amee's perspective on fair housing issues. I will tell y'all, in general, fair housing issues are very, very broad. This could be a 5-year-long class. So Amee is just basically going to cover the nuts and bolts and give you some information that you need to be keenly aware of. I highly encourage every agent. I am also the qualifying broker of Maximum One Greater Atlanta Realtors, and I encourage every agent, I don't care who holds your license, to take a fair housing class every year, just to learn, just to stay on your toes regarding what's going on. Fair housing issues are, it's just something to be aware of in our industry, regardless if you are a leasing agent, a property manager, or residential real estate, or even commercial real estate. You need to be aware of the fair housing laws and what constitutes a violation or a potential violation. And also, I think it is awesome that you be able, as a real estate agent, to demonstrate that you do take a fair housing class every year, and you have that on your record with the Real Estate Commission to show that you are doing everything that you can to stay up to date with the fair housing laws. I will also tell you, we are so excited, and I'm not exactly sure how it happens, but our Zoom classes, our CE classes that we offer virtually, remotely through Zoom, somehow get out to agents throughout the entire country. I will let you know that CE credits are only applicable for your Georgia real estate license. So if you are on this Zoom call and you are not a licensee in the state of Georgia, you are absolutely more than welcome to stay on. Fair housing laws are federal and state. But the CE credit is only for your Georgia license. CE credits will be recorded within 3 to 5 business days after class. So what we're going to do is I'm going to go through the notice to students. I am going to hand the controls over to Amee Davis. We are going to take a break. After the break, there is going to be a CE course evaluation that you will see via a poll. And for interaction, because you guys are all on your computers or phones or laptops or iPads, we do ask that you do need to participate via the chat function. So if Amee asks you a question, please type in your answer in the chat function. We will ask you to type in your name, email address, and license number again after the break and at the very end of class before you leave. Again, just to ensure interaction, GREC requires that we know that you are actually in the class and paying attention, and did not just turn on your computer at the beginning, walk away for 3 hours, and come back. So let me share my screen and go through the notice to students, and then I will turn it over to Amee. So give me 1 second to do that because I lost my controls. And I see some familiar faces and some new faces, so welcome. I know some of you guys have been on Zoom. If this is your first Zoom class, welcome. And me make this just a little bit, I guess it would help stop squinting. Let me make this a little bit bigger so you guys can all see it. All right. This is the notice to students for the virtual broadcast of continuing education of a GREC, Georgia Real Estate Academy approved classroom class. The Georgia Real Estate Academy, GREC school number 6915, with the end date of renewal being December 31st, 2022, presents to you this class. Know who is protected under fair housing and what the laws are. GREC course number 62099. This is a virtual remote broadcast of an approved in-class course, 3 hours in duration, approved by the Georgia Real Estate Commission for the purpose of CE. There are no prerequisites to receive credit for this course. Again, so excited to welcome Amee Davis of Davis & Associates Attorneys at Law as the instructor. There is no homework and no required written exam. You must be on time and present for all remote virtual broadcast instruction hours in order to receive credit. Roll call and documentation of your real estate license number will be conducted via the chat function at the beginning and end of the class, as well as after the break. Students may only receive credit for a specific course number once every 12 months. If you've already received credit for this course, and again, you guys, it's the course number through this school. It's not just the topic. You could take 3 more classes on fair housing and get credit just as long as it's not this specific course. You only get credit for any one specific course number every 12 months. So again, if you've already received credit, you are more than welcome to stay for the information, but you don't get additional credits. No recruiting for employment opportunities for any real estate brokerage firm is allowed in this class or on school premises. Report promptly any effort to recruit on behalf of a brokerage firm by anyone, including a fellow student, to myself, again, Dana Sparks, Director of the Georgia Real Estate Academy, or Heidi Kelly, who is the coordinator of the Georgia Real Estate Academy. There is our contact information. If you want to pull out your cell phone and take a snapshot of that, so you will have that. And Heidi is also the one that will record the CE credits, again, 3 to 5 business days after the class. So let me, oops. All right, I am going to, I did stop the share. All right, I'm going to mute everybody, and I am going to throw the hostessing duties over to Amee. All right, Amee, you should have the host.
Here. Okay, everyone. Hi, how are y'all today? I know it's hard because I can't hear everybody because you are quality muted right now. Okay, I do want to point out one thing. I'm seeing a lot of people on here and very few people have entered their names on the chat. If you want to get credit, you're going to need to make sure that you put all of that into the chat. So your name, license number, and email. And for those of you who either do not have video or you do not have your video on, I'm going to need you to check in every few minutes on the chat. Just type in on the chat your name so that we know that you're here, so that we can actually show that you were participating in the class for the full 3 hours. It's the only way that we can give you credit. These are not our rules. Dana and I don't make the rules. We just have to enforce what we are told that we have to do. So I'm going to sort of jump right in, tell you a little bit about myself, and then get right into all of the fair housing issues that we're seeing. They are wide in breadth and very deep in detail. This is, as I told Dana yesterday, not a sexy topic to have to teach. It is not the topic that I enjoy teaching the most, just because there's so much minutia in it. And I have a great grouping of documentation that I'm going to go over with you that has just a ton of examples and questions and answers that Department of HUD have given us directly. But I'm also going to talk to you about some of your forms and some of the common practices that I think are going to be problematic for realtors. And when I say you or y'all, I'm Southern, guys. I'm going to say y'all a lot. I always have. When I say that, I'm not talking about any of you individually on here. I've worked with quite a few of you in the past, but I'm really talking about your industry. So I want to make sure that you guys understand that it's like being in church and somebody's staring at you and you feel like the preacher's talking directly to you. I'm not, I promise. I am just giving you the information that you need. But I do want to talk to you about some examples of some things and some overt actions that I think are going to be problematic. It seems weird that we are in 2020 and talking about this, but 2020 has not been fun for most of us anyway. So we're going to get to talk about fair housing, right? Okay, so my name is Amee Davis, as Dana has already introduced me. I have been practicing real estate law now for 20 years. Been doing this quite a long time. I know I started when I look like I'm 12, right? So I've done this for quite a bit of time. And I have seen some things that are extremely problematic to both fair housing. And then I've also seen some things that I'm going to try to share with you that hopefully will keep you informed of what you need to be aware of and what you need to look for, and just what you need to do in general. I always say with fair housing, it's easy to do the right thing, but sometimes it's hard in the gray areas to know what your clients are allowed to do. Especially when it comes to landlord-tenant issues and things of the ilk. So I am going to not spend a ton of time on landlord-tenant today, just simply because we could spend 3 full hours on just landlord-tenant. So I'm not going to do that, but I am going to hit some of the high points for you so that you know some of that information. Dana was gracious to share with me her PowerPoint that she put together for the class that she taught. So I'm going to use that some. I'm not a big PowerPoint person because I get into sharing with you information and I forget to change the slides. So I don't do great on PowerPoints and they tend to make me go to sleep. So I am going to do just the part right now that we need to go over. I do want to talk to you about who is protected first. I know that this is, and I'm going to try to share my screen. My computer was acting up just a little bit earlier. So let me see if I can share my screen with you guys and get this open so that it will work properly. The way that Zoom works is you have to open your documents and then you can share them. So it takes just a moment for that to happen. So let's see here. I am going to go to, I don't want to do polling yet. I'm going to share the screen. So let's see if we can do this. That is not.
We see it, Amee.
Okay, so the poll, can you see that poll that I launched? I did not mean to launch.
No.
Okay, good. All right, I am trying to get that off of there.
There's a thing that says end poll at the bottom.
I didn't launch it, so it's not letting me close it. Give me 1 second.
Oh.
Yeah, 1 second, and I will see.
Maybe if you click somewhere outside, it should get rid of it.
See here. There we go. Now I did it. Okay.
And now we don't see your screen anymore.
Yep, got it.
Okay.
Thank you.
Now we see
Okay,
it.
okay, fantastic. So I'm going to skip through some of this because Dana has already went through a huge part of this. So I didn't make any changes to it. It actually went right along with a lot of what I was going to talk to you all about. I want to talk to you first and foremost about who is protected. There is a large group of people that are covered under Fair Housing Act. So people that are protected, it prohibits discrimination because of, and there's a grouping of 7 major factors: race, color, national origin, religion, sex, family status, or disability. I actually received a call yesterday from a client who was curious. She has a client that is renting out a property, and they were extremely curious about whether or not they would have to make any type of changes to the property if they allowed somebody in a wheelchair to rent the property, and how to get out of that. Well, one of the big issues with fair housing is you can't discriminate against someone based on disability. And the disability one on this one is a newer area that we're seeing a lot of movement in, both for mental and physical issues. So I want to let you know about that. But those are the 7 things that we are mostly looking for. And if you're in a closing, one of the things that I always have to go over is an Equal Housing Opportunity Act form. And this is exactly what it's related to. It's these 7 things: that the lender cannot discriminate against a potential borrower for race, color, national origin, religion, sex, family status, or disability. Georgia actually was on the forefront of some of these things many years ago in passing some of this, and then the federal government also has their own rules. So these are some big topics, but those are the 7 things that we're going to look at mostly. So one of the bigger ones that I'm seeing also is beyond disability is national origin. This one is coming up a lot with persons moving here from other countries and what they can do and what they can't do. Discrimination is discrimination is discrimination. I say it all the time. If you're in doubt, don't do it. That is the easiest way to overcome some of this. But we're going to go into some of this into pretty particular questions. Dana has set up a little quiz for you guys. So I want to go over a few of these questions with you and just see where your sort of baseline is. And you don't have to answer to me, but I do want you to see where your baseline is on this. So under federal fair housing laws, is it legal to prohibit the following? It is legal to prohibit which of the following in a housing unit? A, smoking. B, a live-in caregiver for a resident with a disability. C, drinking alcohol. Or D, both A and C. This one's pretty easy. You can prohibit smoking and drinking alcohol. You cannot prohibit a caregiver from living with a resident with a disability. So even if you have a 1 resident property that you're leasing, you cannot prohibit them from having a caregiver there. Okay. Which of the followings are violations of potential or potential violations of Fair Housing Act? Seller tells you he doesn't want to sell to African Americans. Sales associates put the phrase adults only in an MLS listing. Both A and B or none of the above. It's both A and B. Some states prohibit leasing for short-term rentals to underage persons. You'll see that a lot in beach communities, and they're able to do that, but they can't say adults only. So just so that you're aware, there's certain language that you can't use. Under the federal fair housing law, the 7 protected classes are what we just talked about: race, color, religion, sex, family status. Is it family status? Yes. National origin, and what? Disability. So B. And then I want to go over this one too, because this one is some good information, and you can pull these forms. There is actually a handout that you can pull, and Dana gave the guys that at the very beginning. You can go in and pull this if you want to keep that and look over it later on. Fair housing law prohibits all of the following except which? Refusal to show, sell, or rent the property because of a disability, expressing a preference for young adults in a listing comment, evicting a current user of illegal drugs, marketing your listings exclusively in a religious publication. And that would be C, evicting a current user of illegal drugs. So you can evict someone for illegal activity. You can't do the other things. One of the big ones I want to talk to you about is your marketing. And this brings up a really good point. We have had a lot of questions, and this is the only part of this I'm going to address with you, about the issues with coming to the market soon properties. And I know a lot of you do this. I will tell you that in the publications I have read, there is a lot of argument about fair housing violations with this coming to the market stuff. And I'll tell you why. Because they're putting it on coming to the market soon, and they're putting it on typically their email or their Facebook or their sphere of persons that they do business with. And their sphere can be limited very easily by the acceptance or non-acceptance of someone as a friend on social media. And as such, it can also be a situation where you delete people very easily. Fair housing requires that you open the opportunity up to everyone. So there's been a lot of debate, and I'm not going to get into the debate of my thoughts on this. I'm just going to tell you what the debate surrounds, whether or not the coming to the market soon issues are issues that are violations of fair housing. Many of the realtors that use it as an opportunity for them to be able to come in, list their show the property as coming to the market soon, which FMLS allows for them to say, and they have to show when it's doing. But we also have seen a lot of situations where they allow people to get advanced viewing, or to be able to enter into an advanced viewing opportunity above putting it, or before putting it in and making it open to everyone in the market. We've seen a lot of this, and we've seen a lot of complaint about it. I'm letting you know it might be a change that we see coming. We haven't heard for sure yet on how that's going to happen. But what I will tell you, it is a very contentious point of argument. And I have seen quite a few attorneys go toe to toe on this, on what they think is accurate for this. When you are limiting a sphere, limiting an opportunity to a certain sphere or group, I have a client who has two different Facebook groups. And one is her, typically her church group or her personal friends, and one is her business group. It depends on how you're setting that up and who your sphere of influence is setting out to. I'm not telling you it's completely wrong. I'm not telling you it's completely right. I'm telling you, be aware of how you're doing the come into the market soons and how you're opening that up, and whether you're allowing viewing opportunities in advance or scheduling opportunities in advance, and the information that you're putting out there on it, because that is one of the points of contention that we're seeing a good bit of information coming in on. If you have questions, put it in the chat, and Dana and I are monitoring that. So as questions come up, we will come back to those. The Civil Rights Act of 1866 does which of the following? It does two things. It grants all citizens the same rights as white citizens to own, purchase, lease, transfer, or use real property. It doesn't, B is not one of your answers, so I'm going to go ahead and go over C. Effectively prohibits all discrimination in real estate based on race. So this has been in existence since 1866, which would allow everyone to have the same opportunity, and opportunity to buy a property, see a property, rent a property, or any other thing that could be charged as a discriminatory act. Based on fair housing law, which of the following people would be protected? A divorced female single parent, a 35-year-old single Jewish man, and a 55-year-old white man. D, all of them are protected classes, because you're describing them by a specific status, which is, their family status, their religious denomination, their ethnicity, their race. So all of these are protected statuses. When a prospect inquires about racial makeup of neighborhoods or schools, you should respond by saying what? I believe the neighborhood has a few Hispanic families. I can check and get back to you. Fair Housing Act prohibits me from providing that kind of information. I recommend you contact the school district, municipal government, or local library. You can also refer them over to the census data. Most counties keep census data on one of their websites so that you can see it. So you can go there. I wouldn't worry about that. The neighborhood is safe and schools are good. Please do not ever tell someone that the schools in an area are good, because what you think may be good might not be what is right for them. Make them research it. Residents in the neighborhood value diversity. You'll fit right in. So your proper answer obviously is B. Fair Housing Act prohibits me from providing any kind of information such as that. Don't be surprised to hear that there are actually people who go out on behalf of boards of realtors in states and on behalf of HUD to see if discriminatory actions are taking place in certain regions, or even just across the board. I'd heard of this a long time ago, not so much anymore, but I am hearing some of it now. If a seller using a real estate agent refuses an offer because of the buyer's national origin, who may file a federal lawsuit against the seller? The buyer, the real estate practitioner, the federal government, all of the above. And don't be surprised that the federal government can get involved in these things, and they can and will file actions for discriminatory on discriminatory basis, depending on what the situation is. Looking at the following 4 marketing examples, identify which one is okay. Advertise only in a strategically limited geographic area that is populated by a particular ethnic group. Obviously, that's not going to be your correct answer. Limit advertising to small papers which cater to particular religious groups of people. Promote a listing only in selected sales offices and communities with similar ethnic populations. Advertising your knowledge of a language other than English in an English language advertisement. look at this and watch. Advertising your knowledge of language other than English in an English language advertisement. That is absolutely okay. So if you speak other languages, you can absolutely advertise that you speak other languages. But this right here is where the question is coming into this coming to the market soon stuff and how those are being handled, in whether or not they violate fair housing, because it tends to lend the question of, are they only marketing to their sphere? And what is their sphere and who is in their sphere? Is it just people that they go to church with, or is it people that they only work with, or is it people in a certain geographical location? In an ad for a small 2-bedroom house in a neighborhood where many families live, which of the following language is improper under Fair Housing Act? Small, cozy home and quiet neighborhood, 2-bedroom home near playground and senior center, close to award-winning schools, or D, no children. We cannot advertise no children. Which of the following features are required in ground floor units of non-elevator multifamily building of 4 units or more built after March 1991? I want to make sure that you guys understand this. These are ground floor units. They are non-elevator multifamily buildings. So they're typically like a quad or a, something that is usually one level. We see a lot of the one level homes. You need to be careful with some of the language that you're using there too. An accessible building entrance or an accessible route for persons in wheelchairs, accessible and usable public and common use areas, light switches, electric outlets, thermostat, and other environmental controls in accessible locations. And the answer to that is D. So this is a disability issue that we are seeing come up more and more. We are often seeing people rent homes and making minor modifications to the home, such as a wheelchair ramp, lowering some of the light switches within the home so that the person in the wheelchair can reach them. We've seen quite a few things going on in this arena, and there is becoming quite a large question group of what can the tenant do to make the house feasible for their use. Let's see here. Does this symbol equal housing opportunity appear on all of your marketing? It is not a requirement. However, it is an opportunity for you to advertise that you are knowledgeable about fair housing. So if you are taking the right courses, you feel confident in what you're presenting to the public, you feel confident in what you're talking to your clients about, it doesn't hurt for you to use that logo on your marketing materials. Protected classes under fair housing, it is absolutely your responsibility to know. I had a client years ago come in and was extremely upset because she had a client that she knew was wanting to participate in some discriminatory behavior. And her first thing that she did was took them one of the HUD.gov forms for fair housing and made them sign off that she gave it to them. And as she got into that, she was able to refer them to different things of what they could and could not do. We went over the 7 classes, so I'm not going to talk about that, but I do want to talk to you about a new hot button topic. This is one of those topics that we're seeing a lot in law right now. We're seeing it a lot even in the election right now. I want to talk to you about this because the sexual orientation and protected class issue is something that we need to go over. And there are a number of cases in law right now that could flip some of this. So is sexual orientation a protected class? And the answer is that the federal law does not protect people against housing discrimination based on their sexual orientation. However, a bunch of cities and towns have included it in their anti-housing discrimination laws. Just note that in 2017, a federal judge ruled that sexual orientation and gender identity are protected classes under Fair Housing Act. So in the new Fair Housing Act, we have not changed who is protected from the 7 classes, but they are starting to broaden the definitions of this. I would not be surprised if in the next 6 months, even to a year, if we don't see HUD actually, although we say sex is protected, we don't say sexual orientation is protected. I wouldn't be surprised if they don't actually define that separately. Is age a protected class? It does not ban discrimination based on age. However, when you get to loan programs, and many of you have seen this with your buyers, they cannot discriminate against a person based on who they give a loan to. It is a forbidden act to discriminate against somebody based on age, but it is not necessarily a protected or expressly banned, but it is banned under broader definitions of the rules. Where you typically find that is under family status, or they'll add language in under the broader definitions of sex. They'll talk about age and some of those. So it is banned under that, and also under family status. Now, I'm going to talk to you a lot about what's called HOPA. I'm not going to get into that one right now because there are a lot of these slides on it. So I will go over that with you. And if you just remember fresh corn, it's an easy way to remember this for the protected class: family, religion, family, status, religion, sex, handicap, color, race, national origin. So there's no E or O, so it's easy to remember because for equal opportunity. So family, status, religion, sex, handicap, disability, color, race, national origin. I was actually informed yesterday of a case that came out discussing the terms disability versus handicap and the use of those. So be careful with that. I would use disability, not handicap, right now, because there are some cases sitting in law about which ones are used and whether it was discriminatory action to use the word handicap in some of real estate flyers. The fair housing disclosure, seller acknowledges in the non-exclusive listing agreement, the exclusive listing agreement, and then the non-exclusive buyer's agreement that the broker is committed to providing equal housing opportunities. If you get in a situation where you have a buyer or seller, especially sellers who are acting on this, and you feel that they're doing something that is discriminatory, you have it in your forms already, in the pre-printed forms. And Dana, I know there's some chat questions and I will come back to those in your pre-printed forms already on what you and your broker are committed to doing. And it's really easy to go back to them and say, we don't participate in that type of behavior. Discriminating against sexual orientation in Georgia, the seller and broker agree not to discriminate against sell property based on race, color, religion, national origin, sex, family status, or disability, sexual orientation, or gender identity. So you can see that there. And then I want to show you this one. I'm sorry, that's showing double click to edit. I did something on this when I was messing around with some of this last night. You will see when they sign, it says that they agree not to participate in discriminatory actions against any of the other parties. So you'll see that there. And what about discriminating against sexual orientation as a realtor? Realtors should not deny equal professional services to any person for reasons of any of these issues. Realtors should not be parties to any plan or agreement to discriminate against a person, religious, sex orientation, handicap, disability, etc. Realtors in their real estate employment practice should not discriminate against a person based on those issues either. So if you are looking to hire someone in your real estate practice, you need to be aware of these issues as well. I know that most of you, you're here to get your 3 hours of credit to show that you did your fair housing work. But believe it or not, I'm always astounded that at least once a year, I get a question pertaining to something that is covered under fair housing. So although you may know this, it's really good just to know the high points, the verbiage, and the language that is used so that you can help other realtors. Dana and I had talked about this a lot, and I talk about this with a lot of you. We're only as good as everybody else in our industry. The reason that we have in the legal field a bad reputation of what attorneys do and how people see attorneys is because we're only as good as the next attorney standing by us. And I know there are great attorneys out there, and I know there are some not so great attorneys out there, but I also know that there are some really amazing realtors out there. And I know that there are some who maybe don't know all the information, maybe don't take enough classes, don't bother to be informed. about what their contracts say, have their clients sign contracts that they have no idea what they are, what they even say, what they require of the consumer or buyer, what they require of the seller. And they allow them to sign contracts that they haven't even read. So it's hard for them to really represent their client. So I'm a big advocate that when you see somebody doing something wrong, try to bring them up. Try to bring them up to where they need to be. Everybody needs a mentor. I don't care if you've done this 20 years. I don't care if you've done it 50 years. I don't care if you've done it 6 years or 6 months. I'm a firm believer that every single person in our industry needs a mentor. And maybe that person that you're working with doesn't have a mentor, and as irritated as you may be, or mad, if that's a better word for you, in their practices or something that you've seen or something that they've said, I would not automatically assume that there's a discriminatory action taking place without evidence of it, but you can have very gentle conversations with other persons in your profession, especially about what is transpiring. I actually had this come to me recently, had a client come to me and she told me, she said, I am certain that they are discriminating against my client and doing some pretty illegal practices based on the ethnicity of my buyer. Come to find out, it actually wasn't based on the ethnicity of the buyer. It was a problem with the seller living out of state and not handling things very timely. He just moved at a snail's pace in responding and trying to get it under contract to prove to be extremely tedious. So I would not automatically assume it's a discriminatory action. I would look into it and try to figure out what is really transpiring. I get this one a lot also in multiple offers. I have a lot of calls that people believe something was discriminatory and that they chose another buyer based on a discriminatory basis. Just because you submit an offer for more than the value of the listing does not mean that you are going to get the contract. In this day and age, there are multiple factors that a seller can be looking at. How quickly or how long they have to stay, how quickly they can close, how long they're able to stay in the house, when their things need to be handled and what they need to do for their own family plays into it. The type of loan program may play into it, whether it's a cash deal or a purchase with a loan, whether or not there is a contingency for sale of another property. All of those things are taken into play, and it's not always a discriminatory action. It very well may be that is just what works best for the seller. Even if you put in an escalation clause, which there's a lot of controversy on those right now, even if you put in an escalation clause does not mean that you are going to get the purchase. I have had sellers tell me, I don't like the escalation clause. They need to just give me their best and highest offer from the beginning, and then we'll go from there. So I really want you to be cautious about the accusations you make. I've seen a lot of cease and desist letters over the last 2 years about false allegations. So just be aware of that too. What about discriminating against sexual orientation as a realtor? You have several code of ethics and several standards of practice you have to be aware of. Realtors should cooperate with other brokers except when cooperation is not in the client's best interest. The obligation to cooperate does not include obligation to share commissions, fees, or to otherwise compensate another broker. Watch this one. Realtors may not refuse to cooperate on the basis of a broker's race, color, religion, sex, handicap, family status, or national origin, sexual orientation, or gender identity. And this was adopted in January of 2020. This was just adopted this year. Sexual orientation has always sort of come under the sex one, and it was one of those that, or gender identity, it was one of those that it was lesser talked about, but we all knew that it was not appropriate to do, or you could open yourself up to massive lawsuits and claims. So be aware of this. And then one more thing, the following slides present information on the U.S. Department of Justice as of September of 2020, and I want you to watch this. Discrimination in housing based upon race or color. One of the central objectives of fair housing when Congress enacted it. Now, this Fair Housing Act was 1968. So in 1968, we passed this fair housing law, and I cannot remember the exact number of pages, but I do know that we've added some thousands of pages since to fair housing. When I talk to you about how the breadth of this gets so wide and so vast, it can be so time consuming to look through. The basics of it, again, are remembering how to discern what the discriminatory process is. And even just outside of these 7 major factors, and then adding in sexual orientation or gender identity, you also need to remember a couple of other few things on this, is that there are always other things that can be based in discrimination that might not necessarily be overtly stated in the Fair Housing Act. And we'll go over some of those as well. So we have seen housing providers try to disguise their discrimination by giving false information about the availability of housing. So either saying that nothing was available or steering home seekers to certain areas based on a race. This used to be a practice that we saw a lot during the civil rights movement. Individuals who receive such false information or misdirection may have no knowledge that they have been victims of discrimination. The Department of Justice has brought a lot of lawsuits alleging discrimination based on this. In addition, the department's fair housing testing program seeks to uncover this kind of hidden discrimination and hold those responsible accountable for this. So when I tell you that there are people out there who are testing to see whether or not discrimination is taking place in certain regions, certain housing opportunities, etc., this is where all of this sort of comes from. And be aware that it happens. Now, watch this part of it. Some of the department's cases have also alleged that municipalities and other local government entities violated Fair Housing Act when they denied permits for zoning changes for housing development or relegated them to predominantly minority neighborhoods because the prospective residents were expected to be.
She had a good walk, Bo.
Sorry, Dana, can you mute them? I can't mute everyone. Sorry. And then because those prospective residents were deemed to be predominantly African American, there were situations where cities and municipalities were only allowing certain housing developments to take place in mostly minority areas. Obviously, that is overtly discriminatory. Obviously. So what the Department of Justice seeks to find are opportunities where they can stop this type of behavior and seek to move us forward, if you will. Department of Justice has brought many cases alleging this through their fair housing testing program. And then the other part of this I want to just show you is these tend to be based on race or national origin. There's not a lot of the Department of Justice cases. There are some out there, but they tend to really circle around race and national origin. Okay. It is unlawful to discriminate in housing on the basis of sex. In recent years, the department's focus in the area has been to challenge sexual harassment in housing. Women, particularly those who are poor and with limited housing options, often have little recourse but to tolerate the humiliation and degradation of sexual harassment or risk of having their families or themselves removed from their homes. We have actually seen a case here in Georgia in the last couple of years on this, where a gentleman who owned quite a few rental properties was basically pushing for sexual favors in order to rent properties to people. So this is not something that is no longer happening. This is something that still happens. So I want you to be aware of that. If you have a client that comes to you and there is any prospective opportunity that there is overt proof or there is opportunity that there has been some discriminatory practice, there are organizations that you can refer them to, especially to the Department of HUD. We have offices here in Atlanta. We have offices all over the state. We have offices all over the regions here in the Southeast. There are a number of regions that you can do. And then there are a number of attorneys that I know that work for HUD who can get them to the right place. So basically the department's enforcement program is aimed at landlords who create an untenable living environment by demanding sexual favors from tenants or by creating a sexually hostile environment for them. In this manner, we seek both to obtain relief for the tenants who have been treated unfairly by the landlord because of sex and also deter other potential abusers by making it clear that they cannot perform that type of conduct. Okay. Okay, so let's talk about Equal Opportunity Act, Fair Housing and the Equal Opportunity Act. Department of Justice has sued lenders on both Fair Housing Act violations and Equal Credit Opportunity Act, and they are two different acts. So Fair Housing sets out the 7 tiers, and then Equal Housing Opportunity Act prohibits, okay, so you have Fair Housing that prohibits discrimination based on national origin, et cetera, and then you have Equal Opportunity Act, which basically is telling us that when they have imposed more stringent underwriting standards on home loans or made loans on less favorable terms for Hispanic borrowers. We saw this where they made, I've got somebody who is not muted. Let me just see. Guys, if you have unmuted yourself, if you would mute yourself back, I hear a few of you on the phone and it's giving a lot of feedback. So if you can just make sure that you're muted. And if you're not sure, if you'll click on your picture, it'll say ask to unmute, or it'll have a red icon there. So if you can just make sure you're muted, I would appreciate that. Thank you.
Amy, as I can't do it, but as host, if you click on where it says participants, you'll see a little button that says mute all. Only the host duties.
But it's not. I'm going to try it one more time. I did that, but it's still showing some that are unmuted. Okay, we'll try and see if that doesn't work again. Okay, so one of the big things that we actually saw this when I was first practicing real estate. I've been doing this 20 years, but 20 years is really not that long ago. And one of the most egregious acts of discrimination I saw was against Asian minorities that were moving into our area. Unfortunately, one of the big things I saw was those that were taking advantage of them were often people who could speak their language because they typically didn't speak very good English. And we saw everything from really high rates to very high fees. In Georgia, we passed a law that prohibited that years ago. And then we actually did a means test. So you could not charge, and this is why we get into a situation where the under $50,000 loans have a little bit of a issue with what the lenders can charge to make sure it doesn't violate that means test. So there are things that unfortunately have happened even in more recent years with minorities charging higher interest rates, charging higher closing costs. All of those things have taken place, including with landlords. We have seen it where they refuse to either rent to them or charged higher lease fees or higher security deposits. All of those things are violations. Now, more stringent, this is what we're talking about, more stringent underwriting standards on home loans or less favorable terms for Hispanic borrowers. This was a particular case that they did with Hispanic borrowers, but they've also sued for discrimination against Native Americans, for discrimination against, again, people from Asia, people from Soviet Union, other parts of Eastern Europe, and they're taking action against the private landlords. I want to move on to a couple of other things. Okay, so discrimination against what we call housing for older persons, which are 55 years and up. I want to just tell you, I heard the best description of this the other day, and I was told that we should not call it 55 and up as senior or older persons. We should refer to them as second youth. And I thought it was kind of funny because they said these are usually people who are in their prime of their retirement and they're learning to have fun again because all of the responsibilities of work and all of that are out the door, and now their time is their own and they can enjoy it. So I like the term second youth. So that is one of the things, but the way that we actually define it under federal law is housing for older persons 55 years of age and up. Okay. We often hear them referred to as seniors here, although when you talk about senior housing is 55 and up typically, but we don't do the senior exemptions until they reach, in Cobb County, for example, 62, in other counties 65. Some don't do it until 70. There are places that don't do senior exemption at all. So there are some published regulations on this, and I want to talk to you about some of those now. So I am going to stop sharing my screen for just a moment to talk to you about a couple of things. One of the big issues that I'm seeing with this is the question about whether or not there is actual discrimination against someone being of a certain age class. And there was. I don't know if you guys are aware, but at one time we had lenders who would not lend to persons over a certain age because they were afraid of repayment issues. We can do a 30-year mortgage for a 90-year-old person. It doesn't matter. They are entitled to the same types of loan programs that anyone else would be entitled to. Here's one of the issues that HOPA sets out. And again, Housing for Older Persons Act is HOPA. It was signed into law in 1995. Seems like forever ago, right? Or for those of you who are like me, who are gracefully aging, then you realize it wasn't that long ago at all. But it was signed into law in 1995. And basically what it says is it modified the statutory definition of housing for older persons as housing intended and operated for occupancy by at least one person 55 years of age or older per unit. So this is what we talk about when we talk about our senior living zoning and senior zoning. It eliminated the requirement that housing for older persons have significant services and facilities specifically designed for its elderly residents. It required that facilities or communities claiming the exemption establish an age verification procedures that were legal. And it established a good faith reliance defense or exemption against monetary damages for persons who illegally act in good faith to exclude children based on a legitimate belief that the housing facility or community was entitled to an exemption. So this is an opportunity, and I know what you're going to ask me because I get asked every time I do this. Yes, it does exclude children, okay? And yes, they can exclude it under the guidelines that are set forth in the HOPA Act. For the purposes of HOPA, the housing and community or facility, it has to have a couple of things. It is any dwelling or group of dwelling units governed by a common set of rules, regulations, and restrictions. And a portion of the single building may not be considered a housing facility or community. Typical examples include a condominium association, a cooperative, property governed by homeowners association rules, a municipally zoned area. So if you have a municipality that says, I'm going to zone this as senior living only, they can do that. A leased property under common private ownership, and manufactured housing and mobile home parks. May an owner of a single family houses that are dispersed throughout a geographical area and who is not otherwise exempt under Fair Housing Act qualify as a housing community or facility and claim an exemption. And the commonality on this is no. You can't just go in and say, I'm going to make this a senior housing or a housing community or facility. In order for it to apply, it has to have a relationship between the parties. The dwellings in the unit and the housing unit or facility must share a common set of rules. You can't go in and just say, we're going to deem this house to be senior living only, and these are going to not be that way. So it has to be set up that it's actually community or facility. In order to qualify, here are the rules. They must be 80% capacity, that they be occupied by at least one occupant of 55 years of age or older. So 80% is the rule. The owner or management of the housing facility community must publish and adhere to policies and procedures that demonstrate an intent to provide housing for persons of the age of 55 and up. They must comply with rules issued by the Secretary of HUD for verification of occupancy through reliable surveys and affidavits. There is one here locally that does a pretty good job of this. Once a year, when they send out the dues as part of their covenant program, they are required to return an affidavit of who lives in the property in addition to who owns it, so that way they can verify and their age and verify that those persons and that they're adhering to the 80% rule. Okay, so that's it. So they have to abide by the Secretary of HUD. They have to establish rules to demonstrate that their intent is to provide housing for 55 and up, and 80% of the occupants must be 55 and up. Okay. We've actually had some 55 and up communities where they reached over 80%, but they've tried to evict tenants that were under the age of 55 in there. I do not know what is going to happen with that case. It was filed fairly recently. here in Georgia. So we're waiting to hear on that and see what they say, because they are over the 80% capacity. But the HOA wants the family that moved in to rent it. And they're renting it from her mom, who moved out and went into a senior care facility, and they have 2 kids and they're not very happy about it. What are some types of policies and procedures? Written rules and regulations, lease provisions, deed or other restrictions, the actual practice of owner management of the housing facility, the kind of advertising used to attract prospective residents in the housing community, as well as the manner in which the facility community is described to prospective residents. You would not want to advertise a senior living facility with a young person and their kids. That's not indicative of a senior living facility. The housing community's facility age verification procedures and its ability to produce in response to a familiar status complaint verification of required occupancy. So they would be able to immediately respond. If they had a prohibition on leasing, they would be able to immediately respond with written documentation. I will tell you, I think this is where a lot of our HOAs are getting in trouble right now with the leasing prohibitions. They're saying we're only allowing 5 rentals in the community, and you have to go through this process and it has to be approved. That's great, and those things can happen, but if it's not in your covenants and it's not part of what you've adopted to use, and you can't verify it in writing, you're probably going to have an issue enforcing it. And we're seeing that a lot. May a housing facility or community advertise as adult housing and still demonstrate the intent to be housing for older persons? Here's an interesting answer. The use of the word adult or adult community in an advertisement, sign, or other informational package does not demonstrate an intent to be housing for older persons as defined by the final rule. The use of these terms, on the other hand, does not destroy the intent, but if the facility or community has clearly shown in other ways that it intends to operate as housing for older person and meets 80% requirement and has in place age verification procedures, the intent requirement can be met, even if the term adult is occasionally used to describe it. But it should never be the sole descriptive factor. Okay, let's see here. I'm going to look at your chat really quick because I'm seeing that I'm getting a lot of questions. Okay, so I've never heard of this. She said that a builder told me not to bring to his development buyers that were musicians. I don't know that I would know my buyers well enough to know that they were musicians or not. I'm not sure if they just have a thing against music, or not to bring athletes. Well, that's a really interesting one as well. I'm not sure how in the world you tell someone not to bring an athlete in there. Stormy, the document is on the, hold on, and I'll go back and I'll show y'all where the document is to pull from if you're wanting that. So give me just a second and I'll pull that up for you. I can also share it with you via email if you'll give me 1 second. Sorry, I'm trying to go through these. Y'all have a lot of questions. And there are a lot of you that are just apparently going through and doing this. Okay, military members, I'm going to talk to you in just a few moments about, Eddie, because that's a whole different ballgame depending on whether or not they are active duty or not. And then we're also seeing some pretty discriminatory laws, pretty discriminatory practices against people who are police officers and military, which I thought was an interesting one. So I thought that was a pretty interesting issue that we're starting to see come up based on the political environment we're in. Okay, I don't see a whole lot of questions, so it looks like I don't know what some of this is. Okay, some of this is just y'all just checking in. Okay. If you have a question, just put it in chat. Now, I'm going to go through a couple of other things for you. I'm going to leave the HOPA piece of this for a few minutes. And hopefully that helps answer a big part of your questioning. One of you asked me the other day, I don't know if I thought she told me she was going to be on this one for this meeting. If you want the HOPA stuff, it's actually on HUD. And you can go to the Department of HUD website and pull HOPA. So if you have a builder developer that has questions about 55 up community stuff and how to get approved for it, that is on there. Let me look at this as well. Let me see if I can pull this up, guys. Sorry. Okay. Now I want to share with you the 20. This is the most recent one. I tried to find the 2020 trends, but I could not find one anywhere. So this is the housing trends in 2019. In 2019, there were 28,880 reported acts of housing discrimination. Okay. Sex discrimination comprised 6.7% of all complaints. In 2018, 2019, we rose from 139 to 204 cases. That's a 46.8% increase. If you don't think that sexual discrimination still exists, be forewarned, it does. And I'm not here to get into the politics of this. These were the cases that were actually filed and claimed. So percent of complaints by protected class. I want you to see this. I don't know how well you can see the coloring here because they kind of blend, but let's look at this. 59% almost are disability complaints. And we're going to go over this. Many of them having to do with animal support or care support animals. I want to talk to you all about that one today because that's a big one. 16.47% were race. 1.14% were religion. Almost 6% was national origin. 10.7% was other, and then you have color, family status, and sex. Okay, so these are the breakdowns by protected class. Now watch this. Complaints by transaction type. The vast majority of all complaints are obviously rentals. That is the largest group, and that's no surprise. If you look at traditionally the complaints against landlords for any of the protected class issues, they most often come from rentals. And then 16.25% come from all other transactions. And look here what they are. It's sales, lending. Lending is pretty low, actually. It's less than 1%, 0.81%. Insurance is pretty low. Harassment, ads, HOAs, and other. And the other just encompasses any group of information where they just don't have a place to throw it into, or it doesn't comprise enough of a percentage to do it. Sales, though, if you look at this, is only 2.7%. So that is actually way down from previous years. So that's actually pretty good. So not that any one of them is good, but the fact that it's trending lower is a positive thing. And then lending is much lower than it was in past years. So I just want to point out what these numbers are and why. Again, 16.25% are all other types of real estate transactions. And that goes all the way from lending to insurance to harassment, ads, HOAs, everything. Only 2.7% of them are made up in sales transactions, which is fairly low considering the vast number of complaints that were filed in 2019. I anticipate that for 2020, this number of complaints will go up for housing discrimination. So that might be one. I will tell you in 2020, one of the interesting ones is we are seeing a lot of complaints for people with issues of political supporting. Many HOAs have now changed their HOA covenants that you cannot put any political signs of any kind in your yard because it was becoming pretty contentious between neighbors. If you guys have not seen the advertisement out of the two political opponents in Utah, you ought to take a look at it, because in the world of unicorns and utopia that I like to live in, we have a Republican and Democrat who are basically standing up and saying, we might not like what each other does, but we're not going to personally attack each other. And it's a great advertisement if you haven't seen it. But this is a new one that we're starting to see. And I think it's a a pretty good indicator of where we're seeing our country right now. There's a lot of divisiveness and a lot of issues going on in our country, but I have received a number of complaints, and because I don't do a lot of landlord tenant law, I've had to refer them out, but I'm seeing a lot of issues coming in from HOAs telling people they have to take down their political advertisements, and from landlords telling them they have to remove their political advertisements out of the yard. And there is concern of whether or not that is a discriminatory action. And I'm seeing it on both sides. So it's not necessarily geared towards one group or another. I'm seeing the claim being made on both sides of it based on political things. So that might be something that becomes a new issue in the future. But it's definitely an issue for this year because we are in a big political year. 2020 has been just different all the way around. Let's see here. Okay, I have lots and lots of paperwork here, so I'm trying to make sure I go over everything. So I'm going to go over a couple of things with you. So I want to talk to you about what is prohibited. So let's talk about that for a minute. And again, guys, I'm sorry. I know this isn't super exciting material. I know it's hard to sit and listen to somebody for 3 hours. Believe me, I don't like the sound of my voice for 3 hours. So I will do the best I can to keep this as easy for you as I can. But if you have questions, just ask them. I don't have a lot of, I have a lot of paperwork I can give you, but I don't have a lot that I can really sort of show you on the screen. But I want to talk to you about what is prohibited. Let's talk about some very specific acts, and then I'm going to give you some really great examples that come directly from Department of HUD. You can go on there, and I would recommend that you check in about once a quarter on Department of HUD's updates of housing discrimination, because they typically come from recent cases or recent information. So you can check in, and they'll usually give new examples of things that have occurred. So let's talk about some of these. Refusal to rent or sell housing based on what? One of the 7 factors, right? So if you refuse to rent a home to someone and you're a property manager based on race, religion, sex, disability, family status, or national origin, that is prohibited. Refusal to negotiate housing, otherwise making housing unavailable. That used to be a really big sort of trick. Oh no, the house is rented out. And when someone would call on it, but then there would still be a for rent sign in the yard 6 days later. Setting different terms, conditions, or privileges for sale or rental of a dwelling, excuse me, providing a person different housing services or facilities. One of the interesting things is there was an old case that I read years ago, and I want to say I might have even been in law school when I looked at this case. The landlord of an apartment complex would move and place people in the housing complex based on their race, and he would try to put certain people of certain races together in the community. And of course, that's discriminatory action. Providing a person, falsely denying that housing is available for inspection, sale, or rental. Make, print, or publish any notice, statement, or advertisement with respect to sale or rental of a property that indicates preference or limitation or discrimination. So you cannot advertise, obviously, in this day and age. I don't know who would do it, but apparently there are cases where people have advertised certain things that are discriminatory. You would think that in this day and age, they would pick people or have somebody look over their stuff, their corporate attorney, something, but they don't always. Using different qualifying criteria on an application. I am stunned by this one because I had not ever actually seen this. And one of my clients brought an old lending application to me, an old rental application to me that he had found in some archive somewhere. And he thought it was interesting, and it had different application criteria based on race for one to the other. And it was an old application that was used on something for tenants years ago. Evict a tenant or a tenant's guest based on race, religion. Harassing a person. I've seen this one. I was pretty shocked at how egregious this one was. We actually had a tenant who had her stepson move in with her. He had not been living with him, had been off at college, moved in with him, and the landlord got very vehement that he was not allowed to be there, even though it allowed for 3 children, and one of her children had went off to college and he had moved home and there were still only 3 kids living with them. He was very vehement. He began showing up their home all hours of the day every day he would go to their house and knock on the door and go in and do an inspection every day. And that is just tantamount to obviously harassment. Fail or delay performance of maintenance of repairs. We have seen that quite a bit. And then limit privileges, services, or facilities of a dwelling. Discouraging them from being able to buy a dwelling. I don't think this one's good for you. Steering them away from it based on sex, religion, and these 7 things. Assigning a person to a particular building or neighborhood. Again, this is one of those that I was pretty shocked about when I read that case. Excuse me. For profit, persuade or try to persuade homeowners to sell their homes by suggesting that people of a particular protected characteristic are about to move in the neighborhood. This is what you call blockbusting. So what this is a situation where you would have someone of a particular race trying to push people out of an area because a certain group was looking to move into that area. Refuse to provide or discriminate in terms of or conditions of homeowners insurance, and denying access to membership in any MLS or real estate brokers organization. Those are all discriminatory acts against fair housing. I want to talk to you a couple about the mortgage lending. I have talked to a couple of lenders lately about this one, just out of curiosity and trying to figure out where some of this is going. And I've talked to lenders who have told me that if they look at someone's personal credit history and they can tell they're probably not going to get qualified for something, they will talk to them about waiting to apply until they know that they can get them approved so that they don't get denied for a loan and hurt their credit. However, when you refuse to make a loan application or a mortgage loan or give them the same opportunity to get a loan, that is discriminatory. You refuse to provide information regarding loans. So it doesn't matter who your person is. If they call a mortgage lender, they have to share with them the whatever opportunities they are giving to any other client. Impose different terms or conditions on the loan, such as interest rate, points, fees. Discriminate in appraising a dwelling. This is one I just heard about yesterday. Have you guys heard about this one yet? Anybody heard about this discrimination? There's actually a case that's been filed on this. I want to say it was out of Alabama. And the person's accusations are that they had their home set up with their, pictures and the way that they decorated it, et cetera. And the home did not appraise. And they went in and they took their pictures down and made it what they said was more geared towards another racist taste, if you will. And when they did it, the appraisal came up. I don't know, and I'm saying this with all honesty, I have not seen the appraisal. I don't know exactly what they did or not. So I don't know if this is based on discriminatory practice or if this is based on the trends that maybe they don't necessarily like. I'll be honest with you. I keep saying that I think the farmhouse thing is going to go out of style, but it seems like to me every builder is still building farmhouse style stuff. I was pretty shocked by this case. I couldn't believe that because it's an appraisal, we don't use aesthetic appeal for a value of a home. We're supposed to be looking at what? Size, square footage, bedrooms, bathrooms. So the fact that it didn't appraise is a really interesting take on this. And from based on what I have seen of and read of it, the only thing they did was change it to where they felt it appealed to a different group of people. So I thought this was a really interesting case. We'll see what comes out of that one. I'm always interested in cases like this because I'm usually surprised by what the claim is or the action taken was. And then I'm always interested in just to stay up on it, just to see what's happening in our market. I do think that you're going to see a lot more of certain types of claims, excuse me, in the political environment we're in. I'm hopeful that some of this will start to die down soon. Fair Housing Act makes it illegal to harass a person because of their 7 protected statuses. Among other things, it forbids sexual harassment. You can go on to the HUD site and click on the sexual harassment link, and it gives you all sorts of great detail in there on who to contact. threaten, coerce, intimidate, or interfere with anyone exercising fair housing rights and assisting with someone who is exercising the right. I actually know of someone who got into some extraordinarily large amounts of trouble because when they started getting investigated for some improper actions, they refused to participate, turn over, and tried to destroy documentation. And so they got in trouble for that, among other things. Okay, protected persons with disabilities. And I'm going to give you this one little bit. I am going to go into it in much greater detail in a few moments, but I want to give you one little thing. Here is the way the broad stroke sort of paintbrush that works for housing providers and accommodations. Housing providers must make reasonable accommodations and allow reasonable modifications that may be necessary to allow a person with disabilities to enjoy their housing. That is a very broad stroke, because when you use terms like reasonable, each jury can determine that reasonable is very different. I think reasonable is a very subjective term. Can they put a ramp going into the front of the house? Most likely that would be a reasonable thing. Putting a ramp in the garage to go upstairs if they have a wheelchair seems pretty reasonable. Tearing down walls, what was the use intended for? Can their wheelchair access through certain areas of the home? Can they access through the front door with their wheelchair? There are different questions that come into play when you're talking about the reasonableness of making adjustments in a home based on a disability. The one that you guys, I think, will be most astounded by when we get to it is the mental health and pets clause and provisions. So we'll talk about that soon too. So I'm going to go over some examples with you guys, and by that time we'll be able to take a little bit of a break, and then I'll come back and we will do a lot of interactive discussion on some of these other issues. So one of the ways that I think we get in trouble with fair housing is that most of the time there are some very overt, obvious things. But there are a lot of cases where it's not as obvious what someone is doing, or it's not as obvious that this would be a violation. I see a lot of well-intended persons get in trouble with some of the things that they do. So let me read you some of the examples. And this language, any language that I read to you, are the exact wording that comes from HUD. These are not words that I am using. These are words that are coming from Department of HUD or from the Department of Justice, or someone in that someone in one of those organizations. And I'm looking for something to show y'all. But it's going to come from one of them. So it's not words that I am technically using. So I just want to read to you the case. John, who is a Black man, speaks to a prospective landlord on the phone about leasing an apartment. On the phone, the landlord seems eager to rent to John. But when John meets the landlord in person to fill out the application, the landlord's attitude is entirely different. A few days later, John receives a letter saying the application was denied because of a negative reference from his current landlord. John is surprised because he never had problems with his landlord, and his landlord swears she was never contacted for a reference. John suspects that the real reason he was denied the apartment was because he is Black. So John files a complaint with HUD. HUD investigates, and it turns out John was right. The landlord's file shows a pattern of discrimination because of race and color. So what Department of HUD would do is they would go in and they would look at their application processes, and they would look at the number of applicants that they took. Is something that's a real easy way for them to do. The number of applications that they took and the number of homes rented to African Americans or people of color or people of a different race. Jane is a Muslim. She wears I can't ever say this word right, the hat. Jane walks into a leasing office for a large apartment building because she saw a sign in the thank you. A sign in the building's window advertising several available units. Jane introduces herself to the leasing officer, immediately says there are no units available. Jane asks to be put on a waiting list, but she never receives a call. She files a complaint with HUD because she suspects that the leasing officer did not want to rent to her because she is Muslim. HUD investigates and substantiates Jane's claims of religious discrimination. There is actually a case out of New York on this exact thing, and it happened after 9/11. And it was a landlord refused to rent to persons of Muslim religion. What about steering in the form of discrimination? What about this one? John, who is an Asian man, meets with a real estate broker to discuss purchasing a house for his family. When John names the neighborhood that he's interested in, the broker asks John if he is sure that his family will feel comfortable there. I want to ask you right now, just by a show of hands, do you think that's inappropriate? If you think it's inappropriate, just raise your hand. Because here's my question. What other intent can you have in asking, would somebody be comfortable somewhere? When you're talking about housing, correct? Okay. So I want to make sure we're very clear on just that simple of a question, how that can get you into some hot water. Watch this one. The broker went on to tell John that she had a wonderful listing in another neighborhood where there were more people like them. Yeah. When the broker takes John to see the house, John notices that the residents of the neighborhood appear to be mostly Asian. John then files a discrimination lawsuit. Do y'all think that was discrimination? See, that to me is pretty overt. Even though the language initially used was, will you feel comfortable here? Okay. And the will you feel comfortable here, there are better ways if you are concerned that a neighborhood has a high crime rate of handling something along those lines. Let me say this to you. I don't ever want you doing the research for your client. I don't want you to go to the Census Bureau. I don't want you to go to the Crime Statistics Bureau. I don't even want you to look on the Georgia sex predators website and links. I do not want you doing this for your clients. This information should be given and done exclusively by who? The buyer. It is the buyer's responsibility to determine if they want to live in a certain area. I'm going to tell you right now, I've had buyers call me and ask me what I know about schools. You know what my response is? Oh, what county is it? It's Cobb County. Oh, great. Go to the Cobb County website. They'll tell you all the schools, and you can go to some of the school ratings websites. They'll tell you everything you need to know about the school. End of discussion. It is not your place, duty, or responsibility to determine whether a property is suitable for your client or not, other than it meets the criteria of what they ask for: 4 bedrooms, 3 baths in a certain price point. Whatever it is that they're looking for and they've asked you to look for, you can do. But what happens if you have somebody who says, I want to live in a predominantly blank neighborhood? No. No, you can't do that. So what does your response have to be? I can show you homes in various areas based on what you tell me you can afford or what you've been pre-approved for and what you're looking for. And I'll do my best to find you a home that meets the criteria you're looking for. But as far as areas, you have to determine after we look at homes, where you want to live, which home suits your needs. But you cannot get involved in, I want to be in a certain area, I want to be in a certain neighborhood, or I want to be in a neighborhood that is predominantly whatever is said to you. But I've actually heard this one a couple of times this year that realtors have told me that they've heard.
Federal law prohibits me from disclosing that information.
Yes. But it also, if you're asked for this, it's an awkward situation to be in when your client is asking you for it. There are situations where I think you are better off asking or terminating a relationship with a client, especially if they're asking you to do something that you know is discriminatory. You're better off in terminating that relationship. I know it's hard to do that, and I know it's hard to lose a client, but you're better off terminating than ever getting involved in a situation that would lead anyone to believe that you were participatory in any type of discriminatory action.
I wouldn't want to work with them either.
Agreed. So the problem, however, is that some of these questions and some of these things are not as overt. Some of them are sort of hidden in the practice. It's hidden in the language. It's hidden in the way that it's presented. And those are the things that I think when you have a well-intentioned person steps into something that they don't intend to step into or didn't realize. Let me talk to you about this one. Watch this one. John, a person with a disability who uses a wheelchair, views a condominium he is hoping to purchase in a new multi-story building. When John arrives, he finds there are no accessible parking places in the building's parking lot. When John tries to enter the unit, his wheelchair can barely fit through the door and he bangs his arms on the way in. Inside the unit, the thermostat and all light switches are too high for him to reach. The building has a fitness room, but he cannot look at it because the only way to get the fitness room is to go up the stairs. That's it. No elevator. John files a complaint with HUD because failing to comply with accessibility requirements is a form of discrimination. Is he right? Do y'all think so? Seeing your heads, yeah.
I would
Okay.
say, unfortunately, yes, you're right. As discerning as it is, it's right.
You know, it's interesting because when you have amenities that everyone has to pay for, you have to give ample access and opportunity for the use of those amenities. So that's an interesting little tidbit there for you to help with some of these. What about this one? Jane has developed a disability that affects her capacity to manage her own finances. Jane tells her building manager that her mother will be paying for her rent for this reason and asks if all notices related to her rent can be sent to her mother. Okay, does this seem reasonable so far? I'm seeing most of you saying yes. Okay. I see a couple of you saying no. I'll ask you why in a minute. The building manager tells Jane that the management company has a policy of only sending notices to residents, no exceptions of any kind. Several months later, Jane receives an eviction notice because her mother had not known that Jane's rent had been increased. Jane files a complaint with HUD because denying a reasonable accommodation is a form of disability discrimination. Do we agree? When an accommodation can be simply made, accommodations that can be simply made without a lot of extraordinary expense to the owners, etc. Those are the types of accommodations that should not be part of a discussion. They should just get done. Because when you're in doubt, it needs to just be done in an effort to not only protect yourself, to make sure you're not doing an overt discriminatory act. Here's another one. John has 3 teenage children. John's building has a patio with picnic tables, and one day John's children decide to have lunch there with their friends. The next day, John receives a notice from the HOA informing him that the building rules say that patio is for adult use only, and that he needs to make sure that his children do not violate the building rules. John files a complaint with HUD because building rules that discriminate against children are a form of familial status discrimination. Do you agree? Who says no? Raise your hand if you say no. I see some no's. If the use of the buildings is not limited to HOPA, then it can be a discriminatory act. Okay. Now, there are other safety rules that could be in place. For example, pools, you must be 12 years of age because that's a county ordinance. Or state ordinance that you have to be 12 years of age to be at a pool by yourself without any parent. Those types of things can be enforced, but to just in general say that children can't use them, that would be a potentially discriminatory act. What about this one? John and Jane are filling out an application for a mortgage at their local bank. Loan officer notices that Jane is visibly pregnant and asks whether she will be taking maternity leave. Desmond, I see you laughing. You've seen this, haven't you? Yep. I know. I saw this one not so long ago, too. I was a little shocked. When Jane says yes, the loan officer informs the couple that they have to either apply without Jane's income or wait till she returns from leave. I'm sorry, but I've seen too many women change their mind about going back to work. What business is it of his if they qualify for the loan or not, as long as they, whether or not she's going back to work, as long as they qualify for the loan? Now, would it take into account whether or not they could use her income if she was already on maternity leave and was unsure? So the commentary that he made is absolutely discriminatory. can she be on the loan? And we all know that people can be on the loan without having to use their income necessarily. We see it all the time. It's a spouse who potentially doesn't even have income to produce, and they could still be on the loan. But this is one that I actually have seen and was surprised by, and a little taken aback by when the yes, I see, or a domestic engineer was the other one that I heard recently. It was a domestic engineer I saw on a loan application. He said it's called a homemaker, and we've seen domestic engineer on a couple of them lately. But I want to say this to you, it's still discriminatory to even ask. Even in interviews for employment, you can't ask someone's age. I can't ask someone's age if I'm interviewing them for a job. It's just one of those policies. But that one with whether or not the wife is going back to work or not is completely out of line. Now, can a loan officer say, do you want to put this in both of your names, or do you only want the loan in one of your names? Can they ask that general question? Yes, but they can't deny her a loan based on the fact that she may or may not go back to work later on at some point in the future. Okay. What about this one? John recently moved to the United States from Mexico. One day, John sees, have y'all noticed that there's a lot of Johns in these examples? So we have a lot of Johns and a lot of Janes, typical. John sees that there's a new tenant in the apartment next to him, so he welcomes her to the building. John's neighbor comments on how nice everyone in the building seems, especially the building manager, who offered to waive her security deposit for her because she seemed like a nice person. Okay. John is taken aback because the building manager was short-tempered with him and said that John's accent made it hard to understand. John later asks around and finds out that the building manager has waived fees and deposits for other tenants he likes, but not for him or other persons from Mexico. Do you see what he established here? He went around and asked and established a pattern of what? Discrimination based on his national origin. Exactly. So what John was able to do and what this fact pattern shows me is that they are looking for a basis of discriminatory behavior. Now, think about this. If you have a landlord who has, let's say they have multiple houses that they rent out, and they have waived the security deposit for one person who was having an extremely hard financial time, and they think that they did a good deed, and they collected it from everyone else, is that a discriminatory practice? You would have to look at the circumstances surrounding it. And I will tell you what I tell every single one of my landlords: you better treat this as a business, and you have to take the heart and emotion out of it, because you never know what's going to come back to get you. And I'm a big advocate that no good deed goes unpunished. Okay. Some people with the best of intentions I have seen do things that are deemed to be discriminatory, even though they had the best of intentions in doing them. Okay. I am going to stop here because it's 11:30. We're halfway through. Give you guys about a 15-minute break. And then I'm going to come back and talk about what's a reasonable modification. And we're going to watch a little video, and then we're going to jump right into pets and what is protected and what pets are in the protected class of pets. So we will talk about that when we return. So give yourself about 15 minutes. When you come back in, I need you to log in with your name, agent number, realtor number, agent number, and your email again. So you have to log back in. Okay?
Hey, Ms. Davis.
Yes.
One quick question. Is it a violation when, like, landlords they run someone's credit and the credit is not up to par, and then they ask for 3 or 4 month rent in advance?
Here's the whole issue, is that many of these landlords do not have written policies on how they handle various issues, and they sort of fly by the seat of their pants. You can not charge more for rent. You cannot charge more for security deposits and things like that, because you're risking having a discriminatory action filed against you. What I tell my landlords is that you are typically not always going to come into contact with persons who do not have great credit, because in this day and age, many people are trying to buy homes and trying to become homeowners. So there's something that's prohibiting them from doing it. I know people who just rent because they don't want the obligation of owning a house. So I do not think it is a good practice to fly by the seat of your pants, make decisions off the cuff, or shoot from the hip, if you will, in these situations. I do not think it bodes well anytime you have a landlord who is charging any tenant more, no matter what that reason is for, or requiring that they pay more up front. Now, the only option for that is if it is not a, what do you call it, a service animal, and you're asking for a pet deposit. So you can ask for more of a deposit based on pets coming into the property because of fear of damage, but you can't ask for more deposit just because you've run their credit and you think they're a bigger credit risk necessarily. There are other factors that have to be taken into consideration there. Okay.
Thank you.
Does that help? Any questions?
Amy, I have one question. What is your opinion on fair housing if a client asks an agent about the neighborhood and the agent says, well, why don't you just drive through the neighborhood when the school bus is getting out?
Oh my goodness. Okay. Guys, this is a hard one for me because I think I struggle with some of these because when I hear these examples, my brain doesn't necessarily work in the way that these examples are presented to me. So I think I struggle sometimes with what I'm hearing. I will tell you a perfect example here. I have often recommended when people are trying to find out if they should use a certain builder or not, to ask people who have bought homes from the builder what their thoughts are. And one way to do that is to go through the neighborhood and ask the people that have bought, when they're walking around, hey, what did you think of your home buying experience? Do you like the neighborhood? Do they have, if you're looking for a very social neighborhood, do they have social activities that they do? Those are all fair questions. If you're wanting to know about a neighborhood, I would never give the recommendation when the question about the neighborhood appears to be based on anything but the quality of homes built in that neighborhood. Recommend, go drive through the neighborhood and see for yourself. My recommendation to you would be this. If your client seems to be leaning a specific way of what they're looking for, the recommendation is always, it is your duty to inspect the area. And there are so many great pamphlets from GREC for all of you that are Georgia Realtors, and there should only be Georgia Realtors on here, I think, unless you're just wanting the information. There's some great information out there from Georgia Real Estate on there. The fair housing pamphlet, what to do when you're looking to buy a home, inspection things, what all is included in inspections, inspections of the area, including sexual predators in the area, and how to look those up. There are great tools to keep you out of that conversation. And I think anytime you can avoid being a participant in those conversations, you should. So I think one of the great ways to even avoid those is to give your buyers those pamphlets on the front end and have them review them and sign off that they've received them on the front end, because it prevents you from having to have these conversations. If they ask you some questions such as, what is the demographic makeup? What is the socioeconomic makeup of this neighborhood? You can always honestly say, I'm not sure. I don't know. Or I can't respond to those questions because Fair Housing Act prohibits me from answering those questions, because that automatically puts it back on them, and it's for them to do and make up their decision however they're going to make up their decision. Does that help?
Yes, thank you.
Okay. All right, I'm going to take a break, and then I will be back here at, what did we say, 11:50? Is that good? Is that right, Dana? 11:50 or
Yeah, 11:55.
11:55. Okay, great. Thank you.
All right, everybody. Welcome back. Welcome back from break. I hope you guys are doing well. Once again, if you have not already done so, in the chat box, please type in your name, your email address, your real estate license number. If you are attending via telephone, please type in your phone number. I am going to launch the poll, just like when you attend a CE class. There is a course evaluation. So I'm launching the poll, which is our course evaluation, and it is anonymous. It is going to pop up on your screen, and right now there are a total of 4 questions. At the bottom, you will see a submit. It says submit in gray. Once you scroll through and answer all 4 questions, that submit button will light up as blue, and you can click on it and it will submit your answers. Since I have launched it, I cannot relaunch it. I will leave the poll up through the end of class. If you have any technical difficulties with it, no worries. Just do the best you can. If you cannot figure it out or get it to work, just simply click on the minus sign or the X sign at the top of the box. Amy will answer any questions. And again, throughout the course, you may also type in questions through the chat. I am once again going to mute everybody for now. You do have the ability to unmute yourself to ask a question. If you are not asking a question, please keep yourself muted so that everyone can hear the other questions and there's no distractions. You will see a little icon of a microphone, and when you click on it, it will have the red slash through it when you're muted, and you can unmute yourself. So Amy, I am going to throw the hostess duties back.
There we go.
There you
Okay.
go.
Hi, everybody. Okay, let me go, and I've got to minimize the poll because I can't see what I'm doing. Okay, let me go ahead and go over reasonable accommodations, and then we're going to go right into service animals and the difference between service animals and emotional support pets. And we're going to talk about that for a little bit and how that plays into fair housing, whether they're protected, what it entails, what landlords can and cannot do, and what property owners can and cannot do, including what some of the airlines and what the airlines can and cannot do. I don't know about you, but I have seen a whole lot more animals on flights over the last 2 years than I ever have on flights previously. Not that I fly a ton, but I have certainly noticed it, and we're going to talk about that as well. So let's talk about reasonable accommodations and modifications. And so there are just a lot of laws out there regarding housing providers to make reasonable accommodations and reasonable modifications for individuals with disabilities. You see it in every establishment that you go into. You will see ramps, you will see widened doors. Most commercial doors require a minimum, I believe it's 3 feet minimum in width, maybe 4, I can't remember what the exact number is, but they require minimum widths for housing, for commercial properties. And then they also, for certain office units, they have to be able to provide accommodations to be able to enter the facilities for services to be rendered. There are a whole lot of things that can be involved in that. So let's talk about both the purchase side of things, and then also most of this will apply to rentals, but we'll talk about some of it. Under the Fair Housing Act, a reasonable change is a change, exception, or adjustment to a rule, policy, practice, or service. And it makes it unlawful to refuse such a reasonable accommodation to rules, practices, and services when such accommodation may be necessary to afford persons with disabilities an equal opportunity to use and enjoy a dwelling and public and common use areas. Excuse me. In addition, the Fair Housing Act prohibits a housing provider from refusing a permit at the expense of the person with a disability, reasonable modifications of existing premises occupied or to be occupied by such person if such modifications may be necessary to afford full fulfillment and enjoyment of the premises. One of the ones that I saw, one of the cases that I looked at a couple of months ago on this was where in the kitchen sink in an apartment building was in like an island, and the island was built higher than the access in the wheelchair. In addition to the kitchen sink being much higher, the island also housed the cooktop unit as well as the microwave. The microwave was below the countertop, so they could easily handle the microwave, but they couldn't cook on the countertop. And so they made modifications to lower the kitchen island. And the housing unit said, no, you have to pay to put it back in the same likeness. And they sued for discrimination, saying I had a right to make reasonable changes. And so I want to talk about reasonable changes and reasonable modifications. Instead, there's really not a difference under Section 504, which is how they distinguish different terminology. There's not really a difference. Instead, both are captured by the term reasonable accommodations. And under 504, the requirement to make reasonable accommodations applies to a change that's necessary to provide equal opportunity to participate. That's the biggest issue, or to utilize the facility for a home. The accommodation has to be reasonable up to the point that it would not result in an undue financial or administrative burden on the particular recipient or constitute a fundamental alteration of the program or agreement that they have. Under the Americans with Disabilities Act, similar to and based on Section 504, Titles 2 and 3 of the ADA, if you ever want to look it up, Titles 2 and 3 go through this in great detail and require public entities and public accommodations to make reasonable modifications to avoid discrimination against persons with disabilities. The obligation applies unless the public entity can demonstrate that the modifications would fundamentally alter the nature of its service, program, or activity. Excuse me, and I'm going to give you some examples of what does not fundamentally change and what does. Any change in the way things are customarily done that enables a person with disabilities to enjoy housing opportunities or meet a certain requirement is deemed to be reasonable. In other words, it eliminates barriers for those with disabilities to be able to fully use the services of that facility, that location, or that property. Since rules and policies change for different persons with disabilities, then other persons treating persons with disabilities exactly the same as others will sometimes deny persons with disabilities an equal opportunity. So we have to be extremely careful of that, and especially how we present it. Apartment companies, landlords cannot say, for example, a perfect example we had earlier was that they would not send her bill to her mother. You have to click on it and raise it. I see the question about the poll that you can't click submit. You have to click on it at the top and raise it up, like move it around on your computer screen to be able to see the submit button. Under the Family Housing Act, let's talk about examples. Assigning an accessible parking place for a person with a mobility impairment. That is a reasonable accommodation. Permitting a tenant to transfer to the first available ground floor unit that may become available. Adjusting a rent payment schedule to accommodate when the individual receives income assistance for their disability. Adding a grab bar to the tenant's bathrooms. Permitting an applicant to submit a housing application via a different name, or different means. They may have to do it on computer versus handwritten. Or they may have to do a verbal application that gets filled out by one of the parties to answer the questions verbally, so that somebody can fill out the application in writing and give them an opportunity to review it to do that. Permitting an assistance animal in a no pets building for a person who is deaf, blind, has seizures, or has a mental disability. Additional information about that we're going to go over. Anyone that is in the building that owns a corporation, an association, rents out properties, condominium associations, all have to abide by this. Let's talk about what they may ask for to determine whether or not it's reasonable. Please mute yourself. If you're not muted, please make sure you do. I've muted everyone. So if you're hearing stuff, it's because somebody has unmuted themselves. So I have muted everyone, but I'm still hearing people. I'm going to try to mute everyone again and see if that doesn't work. Okay. All right, let's look at this one. When can you deny a request for reasonable accommodation or modification? If the request was not made by or on behalf of the person with a disability, or if there's no disability related need for the accommodation or modification. I want, a taller cabinet or something because I'm, taller or because I'm shorter. Those are not necessarily disability issues. If the disability related need for the request accommodation or modification is not known or obvious, the provider may request only information that is necessary to evaluate the disability and the related disability need. Okay. They can't go in and say, you have to provide me all of your medical records to prove that you have a disability. What they can do is say, okay, if you have a disability that is based on this injury or this matter or this particular physical ailment or this particular mental issue, then I need to have evidence of it so I can figure out what we can do and what we can accommodate based on that. But they can't ask for overly intrusive information. In most cases, an individual with medical records and detailed information about the nature of a person's disability is absolutely not necessary for them to make an inquiry on or to be appropriate. Can a housing provider determine that an accommodation or modification is unreasonable? They can, especially if it's not made by or on behalf of the person with a disability. When a housing provider denies a request for the accommodation, they should discuss with the requester whether it was there's an alternative accommodation or modification that would effectively address their disability related need or burden. So if they have a situation where they have requested something and the landlord can do it for less money or do it more effectively and still accommodate the same thing, they can do that within certain boundaries and reasons. What can I do if my housing provider does not acknowledge my request? You can file a complaint. You can go and speak with them. A failure to reach an agreement on an accommodation request is in fact a decision by the provider not to grant it. So we have had people who are landlords or they run the HOAs who have basically just allowed it to sit for very, very long periods of time, the request. One of them I know for a fact was like over 7 months. It's an effective denial when they refuse to respond. And so when they refuse to respond, it's deemed to be a denial under the Americans with Disability Act and under Fair Housing Act. So both of those, failure to respond is deemed to be in denial. If they have a denial, they can file a complaint, as I said. If they file a complaint to change that decision, then the HUD or possibly a state or local agency will review the evidence and determine whether or not they violated the law and if they're going to require that they make the accommodation. I know that there is a lot of vagueness when it comes to whether an accommodation is reasonable or a modification is reasonable in what they say. The general rule of thumb is if they can do it at very, very little cost or sacrifice, then it should be done, okay, and should be accepted. Only when it gets into large numbers of inability to provide a service, or it gets into a situation where they don't believe, based on the fact that they maybe don't have a disability or it's not been requested on behalf of them to make a modification, that they deny it, would they be protected in being able to deny it? I know that's a lot of information on that one, but that is how it works. If you have a landlord that can easily, allow for a ramp to be placed on a front sidewalk to be able to go upstairs, yes, that's a reasonable accommodation. As they said, bathroom grab bars to keep them from slipping, replacement of anything or additions of things in the home that don't cause vast damage or cost to repair or fix. So I would be careful in denying these. If in doubt, I would make sure that if you do property management, that you have an attorney on standby that has a really good basis in fair housing law, and that person can help you through giving that information to your client, not you directly, but can at least be a referral for you, for your landlords or business owners or commercial property owners that would be able to assist with that. Okay, so don't go out on a hiatus that you are going to give the information. Let the attorneys do that. Does anybody know what can be a service animal? What qualifies for a service animal? Does Anybody
Actually
know?
saw a service raccoon in Nashville 2 weeks ago. He had a raccoon on his shoulder and he said it was an actual service animal.
Okay. Is that a service animal or an emotional support pet?
I think he said it was service. I don't know, but I was just floored that he had a raccoon on him.
Okay. There are some distinguishments though. There are
Okay.
distinguishments about what can be a service animal pet versus what can be an emotional support pet. And the ADA makes very, very broad distinguishments between those. So we're going to talk about that a little bit because it's interesting because everyone always thinks under this new expansion of the ADA for emotional support pets that they are service animals. They're not necessarily. And they make a huge distinction about it. And they also make a huge distinction about what they do. So let's talk about that a little bit. So a service animal as defined under ADA is this. Under the ADA, a service animal is defined as a dog that has been individually trained to do work or perform a task for an individual with a disability, and the task performed by the dog must be directly related to the person's disability. Okay, so watch this. Let me talk to you a little bit about what those services are, because it's quite vast. Animals that would help, let's see here, there's a few lists. A guide dog or a seeing eye dog, as they call it. Hearing or signal dog. This alerts, typically alerts people to sounds. There are dogs that help with seizure responses. Sensory signal dogs or social signal dogs is a dog trained to assist a person with autism. So that they're able to help them. Psychiatric service dogs, and also dogs who are helped there to train for physical things such as opening doors, turning off lights, etc. So those are your service animals. There are other support or therapy pets, but under the definition of ADA, a service animal takes a very specific role, and it doesn't matter their size or for the dogs, it doesn't matter size or breed or anything like that. None of that is taken into consideration if they are deemed to probably be trained. One of the interesting things is if there is a service dog in training, there are certain criteria such as on planes where they can be denied access that service dogs would be, because if they're wearing an in training thing, then they're not technically completed the training process to be able to be deemed a service animal, which is an interesting dynamic on that as well. There are handler responsibilities for service dogs. Service animals must be housebroken. The ADA does not require covered entities to provide for care or supervision of the service animal, including cleaning up after the animal, and the animal should be vaccinated in coordinate state and local laws. So they can require that the animal be vaccinated. I want to make sure that you understand the difference in that, because it's a pretty significant difference when it comes to what things are available. You can go to the ADA and type in service animals and emotional support animals, and it will give you this whole long list of animals that are included, what the requirements are, how they can utilize them, where they can be, where they have a right to be, where they don't have a right to be, and what can be included in all of that. I want to go over a couple of other things with you because there's quite a bit here. If you go to the ADA website, and I want to show you this because this was kind of an interesting thing. This is 26 pages of documentation on emotional support and service animals. That's a lot of information to have to go through, and it's a lot of information to look at. You might want to point your buyers or your landlords there. I actually received a call this year from a seller who was furious that a realtor had shown his house and the lady had come in with a small dog in her hand, and he was furious that she'd brought the dog into the house. There was nothing posted that she couldn't, and the dog was a service pet for her. So, and she did carry the dog while she was inside, but she is a woman who has seizures, and her pet was was a service animal for her. So I want you to be careful of those things. One of the other things that I want to talk to you about is just some of the questions that come up. I received this one recently. Are churches or synagogues required in places of worship required to allow individuals to bring their service animals into the facilities? Religious institutions and organizations are exempt from the ADA. However, some state laws require them to participate and allow them to come. ADA does not override public health requirements. So gyms, fitness centers, hotels, municipalities that have swimming pools, they are not required to allow the pets into the pools. That's another case that I've seen come up. Do apartments, mobile home parks, and other residential properties have to comply with ADA? In a word, yes. Okay. Do federal agencies such as the U.S. Department of Justice and federal Veterans Affairs, we have the new federal Veterans Affairs medical facilities going in, have to comply? And no, because Section 504 of the Rehab Act protects the rights of people with disabilities to participate in federal program services. But they don't have to comply. Rooms to going to surgical, a unsafe or unclean environment for some reason, so they can do that. So they can say no to some things. A hospital generally has to allow service pets to be allowed, and service animals must be allowed where patients are allowed to go as long as they don't provide a health risk to those people that they are going to visit, or in areas where health risk could be posed. If you're having issues with your internet and it kicks you off, log back in and make sure that you go back to chat and put your Realtor number, your name, and your email in there. I know that some of you guys are having issues, and that's okay. Just make sure that you're showing that you're coming out in. I see a lot of people, I see a couple people here saying that I'm going in and out. I'm not showing I'm having issues with the internet. So I don't know if there's an instability issue, but I'm not showing I'm having a problem. So, and I'm showing that I've got 5 bars on my internet connection. So if you are having issues, you might want to log out and then log back in. Okay. Okay, let's talk about this. If someone's dog calms them when they're having an anxiety attack, does it qualify as a service animal? It depends. It depends, possibly. I see a lot of people shaking their heads no. There are about half of you going, no. It depends. The ADA makes a distinction between psychiatric service animals and emotional support animals. If the dog has been trained to sense when an anxiety attack is about to happen and take specific action to avoid the attack or lessen its impact, that would qualify as a service animal. However, if the dog's mere presence is there to calm and comfort the person, that would not be considered a service animal. Does the ADA require service animals to be professionally trained? No. People with disabilities have the right to train the dog themselves and are not required to use professional services. Under the ADA, the dog or service animals in training considered service animals, and no, and here's why: because they have not earned the certification, or they have not been trained before. They must be already trained before they can be taken into public places that allow for service pets to be there. So I would see, I used to see this, and it used to bother me because I don't know why people would do this. It's a hygiene thing for me. When I go to a grocery store and they have a whole bunch of dogs out front that they're trying to get rid of at some of these things, I don't like them being in front of the grocery stores. And here's why: people go out and pet them, and then they walk right in and they touch all the produce in the store. And for whatever reason, it makes me crazy. But I used to see people come in all the time to some of the grocery stores with pets in training, and they would have the support vest on them, or the service vest on them, and they would put service dog in training. They may not have had a right to be there. What animals can a covered entity's employee ask to determine if a dog is a service animal? Here's the thing: in situations where it is not obvious that the dog is a service animal, okay, If they have on a vest, do y'all think that says service animal, do y'all think that is obvious? Probably. Here's what it says. They can ask 2 specific questions. Is the dog a service animal required because of a disability? And what work or task has the dog been trained to perform? Staff are not allowed to request documentation for the dog, require that the dog demonstrate a task, or inquire about the nature of the person's disability. They may only ask, is there a disability? And has the dog been trained to perform a task? That's it. They can't ask anything else. Do y'all understand that? I see some very confused and distraught looks. You don't like it, do you? Here's the issue. We're seeing a lot of people obtain service pet certifications online for 25 bucks. All they have to do is go online and get them. But you can't ask these questions. Okay. I know, a few bad people spoil the bunch kind of thing, but you cannot ask these questions. And I understand that a lot of people don't like this, don't like that they can't ask the questions, don't think that it's not reasonable to be able to require that they provide certification that the pet is necessary. But they don't. So we'll move forward with that. Do service animals have to wear a vest or a patch or specific harness identifying them as service animals? No, they do not. They don't have to have anything on. The handler is always responsible for the care and maintenance of the animal. Can a person bring a service animal with them as they go to a salad bar or other self-serve food lines? Yes, they can. Yes, they may. Can hotels assign designated rooms for guests with service animals out of consideration for other guests? Nope. Sue, I'm going to let you teach this next time. I see you. You're getting them all right. I see you. Can people bring more than one service animal into a public area? If they have more than one service animal, can they? Yes. I actually have worked with several of the dog facilities here locally, raising money for them, and they perform a number of different tasks. Many animals, especially service dogs, in particular, are trained to do one specific task, or sometimes multiple tasks. But I had the opportunity to meet a gentleman who received 2 of the dogs that we helped raise money for training for. He received both a sight dog and a seizure awareness dog. And so he had 2 service pets. They both had very different tasks. Interestingly, the sight dog actually helped train the seizure dog of where to go and how to move him around, which was kind of an interesting dynamic between the 2 animals. But yes, they can. Does a hospital have to allow an inpatient with a disability to keep a service animal in his or her room? Yes. Service animals must be allowed in patient rooms and anywhere else in the hospital that public and patients are allowed to go, provided that they do not present any type of health risk. What happens if a patient uses a service animal, is admitted to the hospital, and is unable to care or supervise for the animal? They can make arrangements for a family or care person to be with them in order to have the service animal with them. Must a service animal be allowed to ride in an ambulance with its handler? Generally, yes. Does the ADA require service animals to be certified as service animals? No. I'm saying all of this, and I know this is well beyond fair housing, but you need to understand some of these because I think it will help you when you get some of these questions on fair housing, what you can and can't do with housing issues in particular. I want to talk to you about this one really quick. Can a landlord deny a tenant for having service animals? What do y'all think? Nope. Okay. What about, can they ask the person to pay a larger pet deposit? No, they cannot. Okay, so let's talk about the 2 pet deposit things. Oh, yes. Let me see here. I'm trying to figure out how to get this to screen share again. So we're going to talk about the GAR form versus the RE form for you guys. And I want you to see the difference. Sorry, it's a lot of paperwork over here that I have. Okay, we're going to do the RE form first. Okay. Let's look at the RE form for pets. Okay. Can you all see that okay? I hope. Okay.
Yes, we're good. We can see it.
Okay. So first and foremost, it's attached to their contract, lease, occupancy, et cetera, et cetera, et cetera. So we're going to go through here, and it says pets are or are not allowed under the agreement. Property owner has consented to pets for a non-refundable fee or a non-refundable deposit in the amount of blank. Property owner may keep a portion of the refundable deposit equal to any damage caused by the pet provided for herein. And property owner shall return the refundable deposit less any portion retained for damages, right? Provided property owner has consented to the pets, the property occupying the property by so indicating herein, this consent is limited to the following pets. Tells the breed, the weight, etc. No other animals are permitted. See, it even goes to mammals, insects, reptiles, and amphibians. Pet owner shall at all times abide by all applicable local laws, the requirement of the property owner's insurance carrier and association rules and regulations with respect to keeping the animal or pets, leash laws, license laws, etc. Pet owner shall, upon request within 5 days, 5 banking days notice, provide property owner with proof of any current vaccinations, including but not limited to rabies, and keep the pet confined on a leash when outdoors, responsible for all acts of the animal, including disposal, cleanup, flea, tick, etc. Now look at this. If in the sole discretion of the property owner or property manager, if the property manager has been identified in the agreement, the pet becomes an annoyance to the public, then they give 5 days notice and demand removal of the pet, right? There's nothing else in here, correct? Okay, now let's look at this one. This is the GAR form. And this is your oops, I'm sorry. I picked up the wrong one. Okay. I wish I was more efficient at the screen share thing, but on the laptop, it's not as easy. Okay, this is the pet agreement, and I'm going to go ahead and skip down. It talks about the pet resident agrees to pay the pet deposits, etc. But here, watch this. It actually has language that discusses service animals. Service animal or emotional support animal owner does not require pet deposit or fee for a service animal or emotional support as defined by the Americans with Disabilities Act as amended. There is no restriction regarding the service animal or emotional support animal with respect to the animal's breed or size. However, the owner of the animal is liable for damages caused by the animal above and beyond the normal wear and tear a human tenant might reasonably cause. This includes teeth marks, marks on trim, carpet torn by a dog's digging, and carpet soiled by dog's waste or vomit. It talks about the service animal registration, description, and registration number if there is one. Permission is hereby given for the resident's pet as described below to be kept within the premises. But they are responsible for any damage that the tenant's pet may cause, whether it's a service animal or not. I will go ahead and tell you one of the ones that I am seeing a lot right now is rabbits. I don't know how many of you understand the depth of issue that happens when you have a rabbit in a house. But they're cute and they're fuzzy, but they will cause an enormous amount of damage to a home. Don't think that just because it's not a dog, it's not going to do a lot of damage. I actually witnessed someone that had a large lizard. I can't remember the exact type of lizard it is, but it not only defecated in the house a ton, but its claws were very long and it would scratch at the sheetrock on the bottom of the wall. And it tore up sheetrock all around the wall. I have seen rabbits pull a string of a carpet and rip it so it looks like there's a missing string all the way across the room. They are responsible for the damage caused by pets. Rabbits chew a lot, in case y'all don't know that. They chew a ton. So those types of emotional support pets can cause a lot of damage. It is always incredibly important, but never, I think, more important than when you have pets, whether they're emotional support animals or not, to make sure that your clients that are leasing are abiding by move in and move out inspection reports, and that you're documenting they're documenting whether or not there's damage to a property before a tenant moves in, and that the tenant is signing off on what damage already existed. That way they can have proof that the damage was done by the tenant, because that's another big thing, is that you have to afford them the opportunity to show proof, whether it was there existing or whether it was not. There is so much documentation that goes along with the housing part of it. There is, if you look under, it's adata.com or .org, I'm sorry, adata.org. And you look up service pet and emotional support. You can look up the Georgia laws on it in addition, but you can also look up how to file ADA complaints if your client needs that. Housing complaints, all of those types of things. I will tell you, there was a landlord in Athens who was violating ADA rules for emotional support pets. I had a client who had a small emotional support pet, and she actually, on a front end of it, so that she didn't have issues, had a clinical letter from her psychiatrist because she suffered from PTSD and anxiety attacks, and took it to the landlord and said, I'm going to have my pet here. And the pet said, the landlord initially said, we don't allow pets, and then charged her quite an exorbitant pet deposit fee for the pet, as well as tried to increase her monthly payment based on her having a pet in the premises. You can't do that. So I'm saying all of this to you because I want you to be aware there's just so much you are prohibited in doing, especially when it comes to your clients wanting to ask for information. We have a lot of people who are moving into properties, and I'm not saying that every one of them is violating or falsifying information. What I will tell you is we have a lot of people who move into leased properties saying that they don't have any pets. They move in and suddenly they have pets. And immediately, oh, these are my emotional support animals. Immediately. Because they know under the ADA rules, they are limited in what they can ask for and what they can request of them. And most landlords will back off of it because they don't want to be charged with a violation of ADA rules. It is a very, very, very fine line. Again, I highly recommend that if you are in property management, that you make sure that the corporate attorney that you refer your clients to, or the attorney that you refer your clients to, is well versed in ADA and fair housing law. Okay. There is also a couple of other bits of information I'm going to share with you. I know we're almost done. I know y'all want to do a happy dance, right? It's just when you're talking about federal laws and regulations, there's just not a lot that makes it super, super interesting. Okay, I want to show you this one. Sorry, I hit the wrong button. Okay, let's do this one. This is a Georgia Fair Housing Act pamphlet. If you haven't seen this, you can look up Georgia Department of Community Affairs. They have some really good information on there. There are a couple of things, and I'll put the link if I can grab it for you real quick because I saved it on my desktop for y'all. I will put the link on it for you. It is the landlord tenant handbook for the state of Georgia. And if you haven't seen that and you do property management, it is a great book. It's through the Department of Consumer Affairs for the state of Georgia. And I'm going to copy and see if I can paste that link into the chat thing. Let me see if I can do that. Hold on. Sorry, some of this is very hard to copy. So I'm going to copy that out to you, but it's called, if you look up Georgia Landlord Tenant Handbook, that handbook has a ton of fair housing information in it, but it also has a lot of really great landlord tenant law information in it, and it's put out by the Department of Consumer Affairs in conjunction with the Georgia Department of Community Affairs. So the landlord tenant handbook answers some common questions. It's available at dca.georgia.gov or under the Consumer Affairs portal. I think it's about 32 pages of information, including information about repairs, things that landlords have to do, things they cannot put off on their tenants to be required to do. They are nonprofits. Georgia Dream is another part of that. So those of you that are familiar with Georgia Dream, it is a part of the Georgia Department of Community Affairs, and it gives you some information on where you can look up Georgia Fair Housing Law, and it also tells you on there where you can file complaints through the state of Georgia for fair housing discrimination and acts. And it also tells where you can go for federal help. Okay. All right. And then I will see if I can put in chat this link. I don't know if it's going to let me. It's not going to let me paste it. But I gave you the information on it. So you can go to dca.ga.gov and pull, or you can just really Google Georgia Landlord Tenant Handbook, and it will take you right to it. Okay, let's look at some of your questions, and then we're going to be just about done. Dana, I know there were a couple questions you were going to have that you had seen, but then I'm going to go in and try to pull this. Even if a tenant moves in not with an animal and then tells landlord tenant is getting a service animal, the landlord cannot deny the tenant. That is correct. Are you saying that if pets are not allowed, you still must allow a service animal in a rental? Absolutely. You cannot deny a service animal in a rental. Tenants should be able to should be asked to fill out forms supplied by HUD, which is to be signed by a medical professional for verification. Phil, you got to be very, very careful with that one. There are some restrictions on that even now. There was a medical professional's verification form, and I believe they recently amended that. A dog can do thousands of dollars in damage. What about odor? James, every animal can do thousands of dollars in damage, whether it's a dog or not. I have actually seen pictures of something a ferret did, and I was astounded that it cost about $3,000 worth of damage to one bedroom. Our emotional support animals are not necessarily forever. Emotional support animals not made. Yes. But it's not the landlord's call to make that determination, nor to tell them that they have to have a time frame in which they can do it. Yes, in some situations, a medical professional can verify if support is needed, but they are not required to provide medical professional proof. Other than to be asked certain questions. You have to be very careful with this. You can ask, is it an emotional support pet and does it perform a task? A service animal, and does it perform a task? For emotional support pets, you have to be careful with that as well on what you ask. American Hospital, okay. I'm seeing quite a few questions here, and then I'm trying to weed through some of the questions. Do not ask. I would be very cautious of any landlord who immediately sends a letter or demands you as a property manager send a letter to state that a pet has to be removed. Yes, you cannot require a deposit for a service animal or emotional support pet. Is that what you're asking me, James? But they are responsible for damage. This is, again, why I was saying it's so important for them to do a move-in, move-out inspection as required, and what is required for that.
Amy, there were some earlier questions about the number of either service animals or emotional support animals.
There's no necessary limit.
Another question is, does and this might not be pertinent to this, but especially on a rental application, or even, for example, we experienced this issue. I experienced this issue as a broker a few years ago, where a buyer was buying a property it was one of those downtown warehouse lofty kind of things, and the HOA had a restriction against pets over 60 pounds. So there was nothing in there, and the buyer had a large emotional support dog that was 90 pounds. So one question is HOA, how does that interact? The other question is, does a potential tenant need to include this in an application that they do have a service animal when creating and when filling out an application?
If they are asked if they have a pet, then yes, they need to go ahead and fill it out. But there's no requirement that they automatically provide that information on the front end. And a lot of people with emotional support pets, I will tell you right now, are telling HUD, and what I'm hearing from one of my friends that works at HUD and is an attorney with HUD, is he was telling me the other day that a lot of tenants and potential tenants that have emotional support pets are not telling landlords that they have a pet until after they move in, because there are a large number of people who feel that they are being discriminated against because they have an emotional support pet and being told no, they can't have the property. So a lot of them are doing it because they're afraid they're going to be turned down for application, which they can't do, but again, we are seeing some of that. Let me pull up one thing. Dana, I missed one of the questions in there. You had another question in there. I know I answered that one, but what was the other one regarding?
One question is about HOA. What about HOA CCRs? And then another related question is, what if the city or county or municipality has, like, if I have an emotional support goat, but there is a city ordinance against not having agricultural farm animals within the city limits. How do you have any sense?
So here's the best thing I can tell you. In speaking with an attorney that he does fair housing, this is what he does. And in talking to him about it, his response is to always check out the local ordinances first and see what the local ordinances require. There are some local ordinances that my understanding in some of the cities and some of the areas that don't allow for certain breeds of dogs that, you know, people tend to think are vicious or whatever. But that they would need to check out the ordinances in their area to determine whether or not they fit within the realm of fair housing or a fair housing violation. None of this is really cut and dry. That's the problem with it, is it's not cut and dry. I can't say, oh yes, it doesn't matter, and they can just go put, and I hate to say this about pit bulls because I tend to not be a person who thinks that every pit bull is a violent dog. But this is the dog breed that many people are very scared of. Just because it's a pit bull doesn't mean necessarily that it's aggressive in nature, or it doesn't mean that it can be in a property either. So it's really going to be dependent upon how narrowly tailored the law is written for that ordinance, and how narrowly tailored it's written for the HOA. But it is something that it needs to be considered. And it's certainly something that if they are concerned about it, that they need to have a conversation prior to moving in with either the homeowners association, the landlord, or possibly a fair housing attorney, because they would be able to better direct them.
And I think one thing, just from a broker perspective, one thing that you said, Amy, for you guys, you agents, when you are working with a seller or a buyer or a landlord or a tenant, the key is consistency. If you can document consistent systems and consistent questionnaires that you use so that you can demonstrate that you are asking this of every buyer, of every seller, of every potential tenant, not just because you have a hunch about this or a hunch about that, but if you can document and show documentation of your consistent systems, I think you will be better protected.
Yes. So when you set out, if you are a property manager, you should have all of these things already sort of in your back pocket, and documents already in your back pocket that you know that you can use and that you can utilize for the protection of both you and your clients, so that you can determine whether or not you can do certain activities or certain restrictions. I would tell you, you have to be incredibly careful with the ADA issue for disabilities, service pets, and emotional support pets. This is a big hot topic right now. I do see what on here is, can a landlord limit the number of people? It looks like it's limited number of people in the bedrooms. It's cutting off here. The answer is maybe. if they advertise that it's limited to a certain number of people, or ordinances limit a certain number of people per bedroom, they absolutely can, but the limits must be done in advance. You must have that stipulated to in advance. In other words, you cannot rent out a property to an individual and know that they have children and not have already agreed upon the number of limits of persons living in that home. We typically, if you have a one-bedroom home, typically, if you have a one-bedroom home, the rule of thumb would be 2 people per bedroom, and potentially one person in a living area for sleeping. The way that they define rooms is very different than the way that an appraiser defines rooms. So if it's 2 people in a one-bedroom plus one more, that would be 3. If you have a 2-bedroom house, it would be 5 people, typically is the rule of thumb, but don't rely on that as being the sole answer. Different ordinances have different things, and local ordinances do not override federal rules. Unless federal rules, when it comes to housing, federal law always trumps, unless the local rule has been upheld by state potential, unless it's so narrowly tailored. We have one in Cobb County that we get questioned on a lot with the non-married persons.
And I think, Amy, too, along with that is, you guys, you be careful what you can say. Be careful in your marketing and advertising and emails when you're saying number of persons per bedroom. I think you run the potentiality of running into trouble if you say number of children, because that then really ties into familial status versus the number of people the actual structure can comfortably hold with sanitation and water and so forth and so on.
Absolutely. And then you also have to look at, so Cobb County has an ordinance on the record that a certain number of married people, a certain number of people not married can live together. And when it's over that, they can't. They also have ordinances for the number of cars to be placed on or to be parked on a driveway or at a home. So that can affect the number of people living in a property. By the way, the one with Cobb County has been upheld on multiple times. So that has happened. Kennesaw says 3 adults with different last names, max per property. Cobb County has, and I don't know what Kennesaw's ordinance says, I'd have to look it up, but Cobb County's is no more than 3 unmarried persons living together. And it has caused quite a bit of havoc in the rental department with our investors. We have had investors very, very angry when they've bought properties and they were not told by the realtors that was an ordinance in Cobb County, especially for the Kennesaw area, for homes that are close to Kennesaw State, because they want to rent them out to college students. It is not your job to check ordinances and the like. But if you know it, you might want to point them in the right direction. If you know that they're looking at doing it, they may be better off served buying the property, elsewhere in order to not be in violation. My own nephew got kicked out of 2 different homes for violation of this one. So I'm quite familiar with it. He went the first time, got kicked out, and went back for more the second time. Okay, let's see here. Yes, they should do their own due diligence, Richard. Okay, anybody else? And Phil, let's see here. What did you say here? Oh, Phil said 3 adults with different last names, max per property. I know Cobb is no more than 3 adults not married living in the same home. I don't know if Kennesaw has their own or if they just follow Cobb. I don't know what it is. And I don't blame you. I would not ask questions. You can give them the HUD form and say, fill this out if you want to, and do that. I don't blame you there. The more you can do that you are not creating the form yourself, and it's coming from Department of Housing and Urban Development, it's coming from the ADA, something like that, then I would strongly encourage you to do that. I believe it's not married. I'd have to pull it, Clarissa. I believe it's not married because there's been a couple of issues with older children living with parents that has come up here in Cobb. And I'd have to look that up for you. Any other questions for me? Because we are about 10 minutes till time to be done. Dana, do you have anything else that you see? I can't go but so far up in the chat group.
No, I don't see anything. I will just say, you guys just be really, really careful as agents, especially back in the, when you're dealing with purchase and sales, and keep your opinion, your history, your upbringing, your lifestyle, your preferences out of your interactions and communications with clients. Strictly stick with the bricks and the sticks of what they are looking for.
Yes. A person wants a 4-bedroom house in a certain zip code because they want to be in a certain couple of school zones. Stick with that, please. Don't go beyond that. Don't offer extra non-solicited information. Do not do the inspections, and that includes any of the exterior things, such as demographics, any of that for your client. I don't ever recommend that you do any of that stuff for your clients. Another big one that I will tell you to stay out of too is please don't go do inspections to make sure that your clients repairs that they requested were done. If your buyer is buying the biggest thing that they will ever buy and doesn't have the time to go make sure that those that the electrical repairs were done to their satisfaction, or to send their inspector back around there, please don't do it. Even if you're licensed electricians, because and I actually talked to somebody the other day, and he said, well, I'm a licensed electrician and I'm a realtor. And I said to him, but you're also confusing your two hats. Try to wear only one hat in a transaction whenever possible. I don't want you wearing multiple hats in a transaction. You're not an inspector. I tell buyers when I'm doing buyer seminars, and I would recommend that this be in your paperwork, that you're going to pay for home inspection and you're going to pay for a re-inspection if you request repairs. Have the inspector go back out and check, make sure it's done. Make sure it's done properly. We've seen a lot of situations come up where realtors have tried to do, again, no good deed goes unpunished, do too much, and then it comes back to bite you. I would also say this to you, I am with Dana on this 110%, keep your opinions and your personal thoughts out of it. I don't care if you think a neighborhood is wrought with crime. If it is in the area that they've asked to be in, if it is the price point that they want in the county they want to be in, you have to show them the property. It's up to them to determine if that home is suitable for their family's needs or their needs. I would be extremely cautious in adding extra superfluous information to your clients. But I see it done all the time. I mean, I can't say that I haven't seen it. I have actually had someone call me this year and say, how do I gently recommend to a client not to buy something in an area that I don't think is very safe? And my response to her was, you don't. You got to show the property. If it's in her price point, you got to show it. And so, that it's up to them to do that. Do you have any questions for me? Now is the time to ask. You guys can turn it off mute if you have a question. What if you are fearful of your safety going to that neighborhood? Okay. I got this question for the first time yesterday, actually, Desmond. I have had, I know there are a lot of safety courses out there for you. I'm not sure what would indicate that an entire region is unsafe. But if you are fearful of going into a property because it is abandoned, if you think there's something illegal going on there, if there's some indication that somebody has been in the home, yes, you can take measures to make sure that you are safe doing your job. However, can you refuse to show someone a particular property? No, you can't. So if you are, completely nervous about going into a location, I will tell you that I say everybody should have a mentor. Call your mentor and ask them to go with you. Call someone else to ask them to go with you. Take another colleague and take someone with you that makes you feel like you are not sort of by yourself. I know a lot of husbands and wife teams where the husbands go with the wives to show property, especially the first couple of times, to make sure that the person is on the up and up for safety reasons only. For those of you that don't know, my sister-in-law is a realtor back home, and the first time that she meets with anyone, she either has another realtor go with her. She has my brother go with her. She has somebody else go with her the first time she meets a client, no matter who the client is, man or woman, just to make sure she doesn't get a weird sense, because in this day and age, you all can't be careful enough, and your safety has to be paramount. So you can't be careful enough in ensuring that you are safe. I'm seeing some more questions. I always try to leave these last few with you for questions.
Hey, Amee, I have a
Yes.
question, Amee.
Yes, sir.
So could you briefly touch upon the differences between race, color, and national origin?
Okay, yes, I can touch on that. And I'm going to give you the definition. So a national origin is a person's nationality and where they're from. So one of the big ones that keeps coming up is, we'll talk about this, Asian or African or Middle Eastern or European. Those are all, is it stone cold? Oh, those are all issues of nationality. Race depends on, when you're talking about the person's race, you're talking about what their, the race is going to refer to how, for lack of a better word for me to say this, they describe for race, you're talking specifically about their color, whether they are white, black, Hispanic, whatever. And then when you're talking about ethnicity, that comes in all different shapes and sizes, because someone's ethnic, when you're talking about ethnicity, you may be talking about South American. That's an ethnic area. So I would be extremely careful in designating any area to be anything. I'll be honest with you guys. I think we in the Atlanta area are very fortunate that the vast majorities of all of these areas are very diverse. There's a lot of diversity in our areas. And I think we're very blessed to not have to see as much divisive housing as some other regions that I hear people coming from other states and other areas see. So I don't see, I have a hard time struggling with where do you want to live, because in my mind, our sole objective should be this person is qualified for this price home, and I have to show them in the school district they want or the area they want to be in, that price home. And so in my mind, that should be your job to focus on, not all of these other things, if that helps any. Does that sort of answer your question a little bit, Eddie? Okay, good. All right. I will also tell you this, that just because you get to work with someone, I love working with people from all over the world. I'm always fascinated about other cultures and other ethnicities and what other people do. I was fortunate enough to be asked to go to a baby shower with some people that I did closing for that I became fast friends with recently, and their culture is very different than my culture, and they are from basically on the other side of the world. And so, you know, it's one thing to be interested in them as a person. It's another to ask leading questions for housing. So be careful with that.
Excuse me.
Yes. Who is talking? If you can tell me your.
Hey, Judy.
Okay. Hey. Hey. Okay. Ask you. Go ahead.
One question. If you have a buyer and taking the buyer to a house, and you are aware that the same house that you're taking the buyer to, the previous owner actually passed away in the house, are you supposed to tell the buyer that information?
If they ask.
If they don't ask, you don't have to.
There's a lot of things that if they don't ask, you don't have to disclose.
Okay, thank you.
And you need to be very careful what you offer. If there is, okay. I know some of you are not going to like what I'm going to say about this, but I never recommend that you work two sides of a transaction anyway, but especially when you're dealing with situations that can become controversial about who lived in a home prior to. And I think you need to really listen to your clients. Certain ethnicities do not allow them to live in homes that have someone that has died in the home. So you need to really listen to your clients. And if you know that's something very important to them, you have to ask them, is this a question you want me to ask the sellers before we present offers? If you find out there's something that's important to them along those lines that maybe you don't have to disclose, but that if you ask, they have to be honest about. Okay.
Thank you.
You're
And
welcome.
that should, from a broker perspective, that should probably be a question you ask. Again, you guys, you've got to demonstrate consistency. If you're going to ask one buyer that question, is it important to you if someone has or has not passed away in this home? You really need to be able to demonstrate, should you need to, in front of a judge or GREC or an arbitrator or a broker or mediator, that you ask that to everyone. And, you know, it may be that you're working with a client that they don't think about it, and then they buy a house, move in, close, and find out somebody passed away in the master bedroom peacefully. Could totally freak out. So again, that, you know, if you're gonna, that probably might be a question that you want to include in your buyer presentation when you are first meeting with a buyer and deciding to work with that buyer as a client or customer or not.
Amy,
Yes.
I may have missed your answer. As the HOA president for a builder, if the CCR state a pet number limit and a weight limit, is that going to be overruled by a service
Yes.
dog size?
Yes. Yes, it is. I'll go ahead and tell you, it is. Yes.
Number
There's
of
actually
pets
some
as
case
well?
law on that. Yes. And if they are deemed to be emotional support or service animals, yes. You cannot prohibit them from getting homes just because you have a limit. However, there are some restrictions that can be enforceable, but the general rule is no. Okay. So the general rule is you can't prohibit most of it. It has to be extremely narrowly tailored. Anyone have any other questions? I know we barely touched the surface on 90% of the stuff we could have talked about. But if you have any other questions, my information is on the chat. I appreciate you guys all attending. I hope you got at least one or two things out of this class that will help you going forward. I wish you all the best of the best for the rest of 2020. And I pray for everyone that 2021 is much better than 2020 has been to a lot of us, with having to be restrained from being and living our normal lives. Although some of you have been out there just living your normal life the whole time anyway. So, and that's fine because that's your choice too. So I do wish you all the best. And if I can ever be of any assistance to you guys, please don't hesitate to contact me and let me know. Okay. Have a wonderful afternoon. Thank you all so much. Is there somebody else that has one more question on here? I'll stay on a few minutes and ask questions for you guys, or answer questions for you guys.
One more question. Can a landlord ask for an affidavit explaining support or service animal?
Okay, no. The basic answer is no, not unless it complies with very specific, very narrowly tailored rules that HUD has set out. There are some forms, if you have questions on this, there are some forms on the HUD.gov website, and there are some question and answers on there about what a landlord can ask and what a landlord cannot. If you are in property management, I highly recommend you go to that website and pull that up, and then also go to the ADA, because you have to take into consideration not only fair housing rules, but ADA rules. So go to both of those and look at the question and answers. They have some phenomenal questions and answer seminars in there, and you just have to look for them, and it's under the document sets. So if you go in there and pull those, you'll be able to see some of those. But it has to be so narrowly tailored, but I would not, I would tell you in general, it has to be so narrowly tailored, and most landlords don't do this well.
Ellen, you have an chat for Amy to send the answer to you via email. Why don't you ask it again, or jot down Amy's email address, and why don't you email your question directly to her?
Yeah, I may have missed some of these guys, and I apologize if I did. My email is, I just put it on there for you. If I missed your question, I'm sorry. They're flowing through so quickly on the chat for me right now, and I'm getting a lot of private questions, it looks like, too. So if you have a private question, just shoot me an email on it, and I'll be happy to help you with it, or give you a link to where you can go to get your answer.
Amy, I saw one question based on the HOPA Act earlier, and this may be Ellen's question. If it's a the percentage of 55 and up, can the balance of that be children, was the question.
The balance of that can be persons under the age of 55, yes. But the minimum standard is 80%. There are also other housing things. There's one, I believe it's Ackworth, that has one that's 100%, and it's deemed to be, it's a tax thing for the municipality that it's in, that everyone there has to be eligible for the school tax exemption. So that one's actually a different type of housing situation. But yes, under the 55 and up guidelines for HUD, 80% must be maintained capacity of those who are 55 and older. That's why their leasing restrictions that are very, very, very stringent have passed this, the means testing on it, because they have to maintain that 80% minimum balance. Any other questions? So just for those of you that are remaining, I'll show you something interesting. We're talking about how low the rates are. I don't know if you can see this number right here. Can you guys see that? 16.21. That is the interest rate that my grandfather paid on a piece of land that he bought for our family farm. So for those of you that are fussing that the rates are going up to 3.5 again, be glad they're not at 16. So people don't believe me when I tell you that rates were that high once, but they were. So just as a little side note, thank you guys so much for attending. I really appreciate you all. Have a wonderful afternoon. Dana will close it out. Make sure that you have re-put your information. Yes, James, my parents was 13% as well. That's what they told me back in the early 80s, I think it was. Dana's going to close everything out. If you have not, please, before you check out, put your name, number, and email, right, Dana? Okay.
Yes, sir.
Have a
All right.
great day.
Thank you so much, Amy. Appreciate it. Thank you guys so much. 3 to 5 business days before this CE credit will be logged on to GREC. Fabulous information. You guys are all independent contractors. You are responsible for your own license. Please check out all of the resources that Amy mentioned. Go to HUD.gov. There's fair housing. There's fair housing for Georgia, DCA. There are a ton of resources, and any and every consumer type brochure you can use. Make sure you use it with your sellers, with your buyers, with your landlords, and with your tenants. Awesome. All right, everybody. Thank you so much. Thank you, Amy. Fabulous.
Thank you.